Yes, sir. Give me the space. Just for 2 minutes.
Mr. Leon, we are getting all of the moving pieces put together here. There are a number of actors. Everyone has to be ready.
Muy bien, señor presidente.
Very well, Mr. President.
Okay. Thank everyone for returning so efficiently. Let's resume the examination.
Thank you, Mr. President. Señor León, veamos.
Mr. Leon, let us look at paragraph 41 of your second statement, please. Do you have it in front of you? Yes, I do. At 41, you're saying, second, in any of these documents, there is any recommendation to encourage the use of force, contrary to what Mr. Bravo indicated in the internal memorandum of March 2019. I never referred to the use of force when suggesting the restoration of public order on the part of the Mininter and DGOP and PMP. To restore public order, restoring public order does not necessarily imply the use of force or the execution of a police operational plan. These entities have other means of dialogue, negotiation, and persuasion. Having read your statement, let us now look at the memorandum that you drafted on March 20th, 2019. This is at tab 46. And this is Exhibit C 576. Do you have it in front of you? What tab? 46. And this document we know was drafted by you. And we also know that it was on March 20th, 2019, since this is what we read at the paragraph in connection with the current situation. Almost towards the end of the first page, it says today, March 20th, 2019, at approximately 150 community members are once again stationed. Do you see it? Yes. And in the paragraph perspective, it says, following the community's decision to resume protest actions as a result of the company's non-compliance, the dialogue has broken down, and the executive has exhausted this channel to the extent that the non-compliance with the commitment has broken the trust and credibility of the actors participating in the process, and any exhortation on the matter in favor of one of the actors could generate a perception of bias that allows for the escalation of the protest measure. Mr. Leon, in other words, so there was no room for dialogue and nobody within the executive should promote this, correct? That's not the case. Should I repeat? As the Office of Social Management, we never give up to have dialogue as the best solution to the conflict. Mr. Leon, here you're saying on March 20th that there is no dialogue. It has been broken down. Yes or no? There was an interpretation of the minutes, basically, and the dialogue spaces have some time, and it doesn't mean that the February 20th session was going to bring an end to that dialogue. This is just the beginning. The lifting of that measure, the lifting of the blockade is just the beginning. There is no set duration. So even though it is true that we were unable and we should not and we do not say that one of the parties is responsible for breaking down the dialogue, as stated here. Because, Mr. President, it could well be that one of the parties decides to state that we are biased. And that is not the role of the state. In this case, the Ministry of Energy and Mines. Mr. Leon, I find it very difficult to understand what you're telling me, because here it clearly states that dialogue has broken down. If dialogue has broken down, it's impossible to continue with dialogue. And for that reason, in your recommendation, you state, given the situation, it is recommended for the public order mechanisms to be activated by the Mininter, which has an action plan for this, but not signed, given that the current policy is one of non-intervention, therefore requiring that dialogue be exhausted as in this case. However, since the beginning of the conflict to date, the policy of non-intervention has prevailed, in relation to which a discussion at the highest level between the deputy ministers is proposed to enable the activation of this plan of action in the face of a scenario like the present one. So, in this case, first, you are saying that there is a need to restore public order, and that this will be done by means of a plan of action to this end, correct? Yes. This plan of action is the police operational plan that you were aware of, correct? No, that is not true. No, the Ministry of the Interior has, as part of its structure, the Office of Public Management. Mininter does not implement an intervention plan. That office, the Office of Public Order Management, is the one that has some ability to solve social conflicts. I apologize, Mr. Leon, but within Mininter does include the police, correct? No, it is not part of that. The police is autonomous in the decisions and their operational plans. My suggestion here is that Mininter, I am suggesting here Mininter, not the National Police. Question, and what is it that you are suggesting? Is it Mininter? Is it for Mininter to continue with the dialogue? Is that what you are saying? Answer, once again, Mininter, Mr. President, as part of their role, includes the Office for the Management of Public Order, and then we hear the discourse from the state, Mr. President, that is different from the Ministry of Energy, and we see a social topic here. The Ministry of the Interior, by means of the OGDP, oversees public order, and this is not part of, this doesn't go together with social the social problem we have. To block that public road is a crime, and it has to be open. And the view of Mininter is exactly that. That is to say, when we see that there is a crime, the actors are identified, and in this type of processes, there is also a prosecutor to prevent the crime, and that goes together with the ombudsman, and they have a different discourse. That is to say, there is a social discourse, but there is a marked difference, and that's the reason why we need Mininter to comply with their role, and we never suggested the participation of the police. That was not our role, and this is not what we do from our agency, from OGGS. Mr. Leon, so you're saying that more dialogue was needed. Is that what you are saying? Correct. And for that dialogue to take place, even though if it was broken down, as you said in that document, correct? That is correct. That is correct, yes, Mr. President. And that in spite of what you mentioned here, that there is a non-intervention policy, that is to say, non-intervention by the police, you're suggesting that non-intervention should continue. Is that what you're saying, in spite of the letter of this document, Mr. Leon? Let me reiterate that intervention was not part of the OGGS. I apologize, Mr. Leon. We're talking about what you recommended. Intervention by Mininter, not an operational plan. And here, you're suggesting a communication at the highest level with the vice ministers to activate this action plan. This action plan assumed just a dialogue, according to your point of view. Yes, that is correct. You're saying in this document, the recommendation is the subparagraph on recommendation. There is a reference to Mininter that has an action plan for this, but not signed. What is the plan of action that Mininter has, the one that you're referring to? That is based on their roles and jurisdiction. No. You're talking about a specific plan. And then later on, you say that allows for the activation of this plan of action. You're talking about, in this paragraph, to a plan, a specific plan. What is that plan? To meet with the community, as I explained before, with various actors of the state, the office of the attorney, the prosecutor, and the ombudsman's office. Did you receive a copy of the plan? Well, that only reflects the ideas that we exchange at meetings. So, was it a specific plan, the one that you just described? Not as a plan, no. They were just ideas. Yes, they were just ideas and guidelines we had. As I have already said, Mr. President, the state has various agencies, ministries. The National Peruvian Police also has a social management office, and the use of force for us was not part of our plans.
President, but just a couple of further questions.
You have mentioned that here there was a crime, correct? And that is the reason why the Mininter had to act. The blockade of roads is a crime in Peru because it goes against the freedom to use the road. And therefore here, this was a crime, right? It is a crime. In spite of the fact that there is a flagrant crime, you're telling me now that police intervention was not warranted, only dialogue, correct? The event going on in connection with crimes do have some grounds, and that's why the Peruvian state is aware that dialogue is the best way to maintain the social peace in an area. And as a matter of fact, and to conclude, Mr. Leon, there was a need to talk to drug traffickers and individuals branding weapons. That's what you're telling us, right? That's what you're telling the people that are here. No, that is not correct. They were not armed. As to OGGS, there was no report. There was no documentation from the company saying what you are just saying, the issue of the weapons and illicit trafficking. I apologize, but you drafted a document on February 20th confirming that they had arms, weapons. The document that you're referring to is a study of the actors, of the circumstances that were presented at a specific point in time, and also as part of a dialogue. We cannot, from the point of view of the state, stop from mentioning those acts, but it is also true that as OGGS, we assessed that if that act or that fact may have any impact on the conflict, and that was not the case because the company told us this is the complaint by the company before the office of the prosecutor. That was not the case. The police never gave us that report. Therefore, we knew that the issue of drug trafficking and weapons was not something impacting the conflict. The conflict mutated, change. Both had mutual accusations of non-compliance, but we were always there encouraging the dialogue. We were also, the company also blamed the company for non-compliance, but we were there. We encouraged dialogue as the best option. After the incursion, after the invasion, we continued to talk about the dialogue and the importance, and that has been a constant conduct. Mr. Leon, if there is a person that attacks your house, the person comes with weapons, takes all of your possessions, and remains there during 9 months, according to you, there shouldn't be any police intervention. Just talking to that person, having a dialogue and attempting to have an agreement even though they are armed and they are drug dealers. Is that what you are telling the members of the tribunal? Are you talking about weapons because of the weapons the company had? No, answer my question. If a drug trafficker goes into your home and stays at your home for 9 months.
Cross-examination, but it is now putting to a fact witness hypotheticals on an issue that is not within this witness competence, which is how you deal with the situation through the use of force, PNP. We're not in a situation where someone goes into someone's house armed and stays during 9 months. It's a hypothetical, and the witness should not be put in the situation having to answer that question.
I respectfully disagree, Mr. President.
I think that the tribunal can sort of anticipate, if the question were put, what the nature of the answer that we would receive. And so I think given that it might not be the optimum use of time. I know the tribunal has a number of questions it would like to put to this witness, so if we hope we could have some time for that, and we do have yet the need for the redirect.
Thank you, Mr. President. That concludes my cross-examination.
Okay, redirect?
No, thank you.
All right, I have some questions. Let me check with my colleagues. All right, let's start with. I'm trying to promote you.
Are you aware, Mr. Leon, that there's a police report that at about midday on the 15th of May, several members of the community disarmed some of the Red Guards, and shortly after one of those guards was shot and died? You're aware of that report?
I do not know, sir. Could you please show me the document you're referring to?
25 on exhibit C640, but before we do that, are you saying that you haven't heard of a report that on the 15th of May one of the Red Guards was intercepted by a few of the Parang community and shortly after was shot and died? Have you not heard of that?
No, Mr. Griffith, no.
Del informe en sí.
I don't know of that report per se. I've not seen that report.
You were closely involved with the community, including in May 2019, were you not?
Dos-
What did you say? It hadn't been translated. Were you aware?
Yes, in 2019. Estoy hablando de esa fecha, en mayo. ¿Participaba usted con la...?
First, wrong channel.
I'm sorry about that.
Question again,
I'll ask
please.
again. Were you closely involved with issues concerning establishing dialogue with the community in May 2019? That's a yes or no.
Es correcto.
That's correct.
And are you indicating that you're unaware of the fact, which is reported in a police report C640, that on the 15th of May, members of the Parang community intercepted some of the Red Guards, and shortly after one of them was shot and died? Are you aware of that incident?
I don't know of the document. I know of the fact, the event.
Document. I'm asking you about the fact. Don't prevaricate. Do you know of an incident on the 15th of May whereby it is asserted that members of the Parang community disarmed and then shot one of the Red Guards who subsequently died the same afternoon? Do you know about that or not?
Yes, I knew that there was a confrontation and that one person died.
Well, arising from that incident, would you regard that incident, which might be described as murder, as being a matter over which dialogue should have priority in its investigation? What's your view of that? Which is the more important, dialogue or investigation of a murder?
The investigation of the murder was not within my authority, within my jurisdiction. There are other entities, such as the National Police of Peru or the Prosecutor's Office. At the OGGS, what we did was engage in dialogue.
So you don't regard that as a relevant matter for the dialogue?
From the government, when we found out about the event that you have just relayed to me, well, we held a meeting with the representatives of the company. We wanted them to see that these kinds of attitudes didn't really help dialogue.
Nosotros
We, in the government, in spite of that incident, we continued, sir, on insisting that the dialogue was the best way to do things. After the incident, we held meetings in Sayan, and this event transpired in May, and our latest interaction as OGGS there was in September. We continued having to deal with these negative attitudes, but we were very aware that from the level of the government, we were always open to dialogue. We were supporting dialogue. It was very difficult, sir, that us, as the government, should not lose credibility. A few days before, we had meetings with the Paran community, and we said that we were going to sit down and discuss and try to do away with our differences. But the companies the community did not want the dialogue. They didn't want dialogue. They felt that they had been deceived by the state. We attended a number of meetings, however.
Thank you. No further questions.
I have 2 or 3 questions, sir. First, early in your statement, you referred to how in road closure cases, your organization always asks for the lifting of the blockade. Do you recall saying that?
Yes, Mr. President.
Have you personally been involved in multiple road closure cases?
Yes, Mr. President.
Can you estimate how many?
4.
In any of those, was there ever any intervention by the police?
There was support by the police for security purposes, safety purposes, in connection with some entities of the state.
All right, so in the 4 cases that you were involved in, there was some role played by the police. Is that right?
It provided security.
I see. It would be interesting to examine those 4 cases, but I'm afraid we don't have time to pursue that. But certainly in your experience, there have been situations where police participation in the resolution of a situation made a contribution. Is that right?
Yes. Again, Mr. President, the police provided support to us in those critical events, specifically when there are situations that are quite important, such as the blockade of a roadway. But we, at the OGGS, we were the leaders of the dialogue.
All right. Now, you have made very clear in your testimony and in the memoranda you sent up the chain that we have read, essentially that you agreed with Paran's interpretation of the agreement and held the mining company responsible for its breakdown. Is that an accurate assessment? Do you understand my question?
bien, realmente
Could you please repeat your question, sir?
Do you agree that under the February 26th agreement, there was no obligation to remove the road blockade? Did not require that the blockade be removed. Do you agree with that statement?
The agreement had to do with the blockade.
If you would answer my question, do you agree with the statement that the 26 February agreement did not require removing the blockade? Or wrong?
Correct.
That's correct.
It did not require removing the blockade. All right, let's turn to the survey. Your understanding is that there was an agreement for a survey to redesign the road. Is that your understanding? It was a road survey.
Yes.
Now, are you aware of Mr. Bravo's testimony that that was not what was agreed? That he has a different understanding of that, of the purpose of that survey? Are you aware of that position?
On the basis of the witness statements, yes.
All right, so you think that the witness is not speaking truthfully when he said that was their concern?
If you allow me to put this into context in 30 seconds.
We have very little time. Did you ever speak directly to Mr. Bravo about this issue? The issue of the purpose of the survey?
It had to do with the access road to the Peran community and consequently to the mining unit.
I understand, but my question was, did you ever discuss Mr. Bravo's concern directly with him?
During the meeting of 26 February, yes.
Okay, on the 26th of February, you did discuss with him his belief that the survey was for purposes of identifying affected land and not for purposes of a road. Is that right?
That's not correct.
Well, I understood that's what you said. Have you ever discussed directly with Mr. Bravo his understanding of what the language of the agreement was supposed to mean?
No.
Now, I'm looking at your memo, the one we were just looking at, C576, and it's captioned protests over the mining company's failure to comply with the payment for the services of a topographer. So in your understanding, the only issue was money and not the scope of the survey. Is that right?
Yes.
Okay. The scope of the survey had nothing to do with it.
No.
Now, let me ask you one last question. I'm sorry to press you, but we really are short on time. No, I'm sorry, I've got a couple of questions. Are you aware of the current situation at the mine site? Operating? If so, who's operating it? Do you have any knowledge of that?
I've heard that up until 4 months ago, there was activity, illegal activity there.
And do you know what happened 4 months ago?
There was illegal mining activities there.
Up until 4 months ago, suggesting that something happened 4 months ago, or that's the date of your information.
That was the date in which we gained knowledge at the office that activities were being carried out.
Okay. Are you currently in any sort of regular contact with the Peron community?
Because of the fact that we work closely with them and with Invicta, yes, we have communications with all of the communities in which we have had an involvement. Yeah, there is a link of communications. Just to say how they're doing, just very simple issues.
All right, well, my last question. I have the sense from your papers, and tell me if I'm wrong, that you regarded the February 26th agreement as a significant accomplishment. Is that right?
That's correct, yes, sir.
Did you find yourself personally distressed that it did not succeed?
No, Mr. President, we know and we understand that and this is part of the dialogue process.
Okay, well, thank you, sir, for your testimony. I think we may have another question from Arbitrator Garibaldi. Thank you.
Mr. Leon, in connection with the 26 February agreement, did you understand that that was mandatory for the parties? It was a mandatory agreement for the parties? That was your understanding? Agreements are made to be complied with. So it was compulsory. Yes. Legally binding? When we have these dialogue forums, you have highs and lows in them. All agreements can be perfected, can be made more perfect. Okay, they can be made more perfect. That's what you're saying? Yes. But is it binding while it is being perfected? Yes, both parties need to abide by the commitments made. These are commitments. These agreements are commitments by both parties in the framework of the process of dialogue. Are they legal commitments? They're social commitments. Are they legal or not? What is it that makes these agreements binding? The binding nature has to do with the fact that the government guarantees a follow-up of the agreements made and evidenced in the meeting minutes. Thank you.
I'm sorry, I thought I was done. You just said the government plays a role in seeing these are followed up on. I thought I remembered someplace in your testimony or the testimony of one of your colleagues that was not the government's role. Do I misremember that?
Mr. President, when you begin a process of dialogue, when you have the first dialogue measure, and that is the first thing that we're looking for is for the blockade to be lifted, and that's an achievement for us. When there is an agreement, we do have an office that follows up on the agreements, but we're talking about framework agreement more. When we are dealing with a more,
I think that clarifies the situation. So again, I don't want to be rude to you, but we have a great deal we have to do yet this afternoon and a limited time to do it. So unless there are any further questions from my colleagues, I thank you for your testimony. You are now relieved. You can begin to have conversations with the rest of humanity, and we thank you for your testimony.
Thank you very much, Mr. President, members of the tribunal.
Muchas gracias.
Thank you.
Sí, ya me voy.
Welcome, welcome, ma'am. Can you introduce yourself for purpose, I take it you'll be testifying in English? Fine, you have a headset there.
I will hear in English. If I don't understand something, I will take the headphones. But
Please turn the microphone on.
To begin with, we need to
Microphone,
turn the
ma'am.
mic on. Push the,
this one? Okay, perfect. I prefer to speak in Spanish, but I can understand English, so I will be hearing in English, if that is okay with you.
it's okay with me. It's a question of how it works for purposes of the transcription. Is that an issue?
No, sir, it's not an issue.
Okay, I'm informed that will work fine. So we'll see how it goes. Can I ask you to identify yourself for purposes of the record, please?
Yes, sure. My name is Millanu Dufour von Gordon.
All right, and you, I'm sure, are familiar with the procedure that's going to be followed here.
Yes.
You should have before you a declaration as an expert. Do you have that?
Yes,
Could you make that declaration, please?
sure. I solemnly declare upon my honor and conscience that my statement will be in accordance with my sincere belief.
All right, thank you, and I'm sure will be the case. Now, are you aware that earlier this week the tribunal made a ruling with respect to portions of your report? Are you aware of that?
Yes, I'm aware, and bearing into mind that, I have modified my presentation.
All right, that's very good. I appreciate that. I just wanted to make sure we were good on that.
Yes.
All right, I think then if there are no further administrative matters to deal with, I understand from council that you will be giving us an introductory report, is that right? Within the agreed 30-minute limit.
That's correct.
Okay, well, we look for your report then.
Excellent. 1 second, please, because I have a PowerPoint.
While we're waiting for the technology, I should have mentioned that if at any point you feel the need to leave the room, and let us know, and we'll certainly accommodate.
Excellent,
But
thank you.
Are we set with the technology now? I see nodding of heads. Very good. All right, please.
I only want to check if... Perfect. Excellent.
Good afternoon, Mr. President, members of the tribunal. Good afternoon to everyone. My name is Mianu Darfur, and I am a lawyer from the Pontificia Universidad Católica of Peru. I have more than 16 years' experience in regulatory, legal, social, and environmental matters in the mining sector. Through the past 16 years, what I've done is to provide advice in connection with the development of the strategy for permitting matters for mining companies in exploration projects and operations projects. Rio Tinto, Lumina, Goldfish, and other companies that work in Peru, those are my clients. As I indicated initially, I have adapted my presentation to the ruling made by the tribunal yesterday, so I'm going to speak only about the licensees that were included in the memorial by the Republic of Peru, the counter memorial. We have two parts in my presentation. The first part has to do with a regulatory analysis of the requirements in Peru, and the second one we're going to speak about social license matters. First, we are going to talk about the regulations in Peru. And the first thing I'm going to talk about the permits that are needed in Peru for mining activities to be conducted. I'm also going to talk about the Invicta project, and I'm going to describe it on the basis of the documents on file. And on the basis of that information, I'm going to examine the insufficiency of the permits for mining and for processing. First, as you can see in my presentation at number 1, I have included here the most important purposes that are required for mining activities to be conducted. First, we have a group of permits that have to do with environmental certification. We have discussed this at length in the past few days for mining and processing activities to be carried out. And for that, in Peru, you need an environmental impact assessment, EIA. If I want to change my mining project, I have to amend the EIA. As at 2018, the date we're interested in, there were two methods to do this. You could ordinarily modify the EIA, or you could have an ITS. An ITS, the technical report, is an easier processing. It takes less time, and also in general, in connection with the ITS, the amendments shouldn't really be adversely impacting the environment significantly.
Sorry to interrupt, truly. But I think that the presentation has not, frankly, complied with yesterday's order. There's discussions of beneficiation, which is not raised, in the Respondents' Counter Memorial, similarly with the respect to water sources and the need for permitting for an alternative water source, not the water system, but a water source. Yet we still see these in the presentation.
Well, let's consider it as we go. So far, we have heard about the EIA. We know about that. We know that it was subject to modification. We've heard about the ITS, which is hardly new. Next item, the mine closure plan. That has certainly been part in play. The stages for the mining operating permit. That has previously been in play. When we get to water use, we may begin to have some issues. So let's not confront our problems till we come to them. But at least I think in the first portion, it looks relatively consistent with all that went before.
Happy to play it as it lays, but I think we will have an issue when it comes to processing.
Let's confront our problems when we confront them.
Thank you very much. Como estabas refiriendo,
As I was saying, in the group of environmental certifications, we have the mine closure plan, and I'm not going to address it here because I don't think it's part of the critical path. As the second group, we've spoken first of the environmental certification. As the second group, we have the mining permits. And here we have two important groups for the mining and the processing of ore. One, the mining authorization, which at that time had two stages. One was construction, and the second was operation. And the second permit related to processing, which is the permit that one must obtain to be able to process the ore. And finally, there are, in mining activities, other activities or components that require permits and that are regulated that are independent of the environmental certification and independent of the mining permit. On this point, I want to specify three aspects that have been discussed this week. The first, with respect to the ITS, Mr. Bravo said that the ITS is a voluntary instrument, which is not so. For the ITS is compulsory when it is presented because that is how one can modify the document. The second point that I wanted to note is in Mr. Castañeda's statement, he said that the environmental management instrument was a responsibility of the environmental consulting company. Here, what I want to say is that, in effect, an environmental consulting company draws up the record or the report, but it is the mining title holder who is responsible for it and for what's established and is the one who is subject to inspection and oversight. And as the third point, Mr. Bravo said that after the inspection of the mining permit, what one would get would be a COM. This is not the permit that one gets. It is the permit that one seeks independently so as to be able to have explosives. What's obtained after the inspection is the mining permit. I think it's important that we all be on top of the same information so that we can have it when rendering the evaluation. Another important point is when I've calculated the time frames, I've calculated average real time frames. And I must say, as you have seen in my report, that this is the common practice in the mining industry. In the 16 years that I've been working on this, I've never presented a timetable with the legal timeframes, with those that are established in the law and regulations. What I do and what my mining clients always ask me for is for me to give them predictable and reasonable timeframes so that on that basis they can have the corresponding milestones at the moments established. But it is important to note that this topic has been discussed. There are timeframes that are established in the law. That is true. But those timeframes don't mean that once it comes, the deadline comes, I get the permit. That's not what it means. What it means is that you follow that, if you follow that timeframe, then the administered party, the mining title holder, what they can consider as a relief is that they've been denied the permit. That's what they can do. And they can then submit a challenge motion so that the next level can evaluate it. In my experience, in the very few cases in which some clients have applied for this relief, the time frame has been much longer than the average times. I wanted to mention this because on the first day,
This relief, which relief are we talking about?
It's an appeal. You can consider if you.
We're talking about an appeal of a denial, is it?
Exactly.
Okay, thank you.
Yes. Comment.
yes, exactly. I say this because on the first day of this hearing, what was said was that illegal timeframes had been used, and that is not so. What I have used are the timeframes which in regular practice are used. And as I indicate, the other timeframes are timeframes that are established in the law which you can appeal. But they don't give you the option to consider it approved, except for a couple of cases of positive administrative silence where it's clearly not, it does not apply to the environmental certification or the mining license or mining permit, where they have to be considered as denied. Now, getting into the description of the project and also for the benefit of the request and the rule that you've established, I have noted the paragraphs of the counter memorial for you to verify that this was covered in the counter memorial, and that is why I'm touching upon it in my presentation. To be able to come up with a permitting strategy, I need to become familiar with the project. And in this case, as has been established by the claimant, an underground mine had been considered with a capacity of 400 metric tons per day, and water use was considered. The water use is necessary for mining activity. Without using water, it's not possible to carry out mining activity. And that is why the EIA of 2009, which is introduced in the claim, suggests that one must use water, and that's why I'm touching upon it. And as regards the processing of ore, once again, this topic has been touched upon in the counter memorial because it's in the memorial. What the memorial indicates is that the processing will be done outside, and there are some options for doing so. Based on this description and the law, I have proceeded to undertake an evaluation as of October of 2018. What permits did the project have, and which ones were lacking for them to legally initiate exploitation of the mine? And I'm going to, there are three: the environmental certification, as we know, that has been touched on quite a bit here, the mining permit to carry out the mining, and the water use, which, as I say, is in the initial document, in the memorial. Now, as regards the environmental certification, that has been a matter of discussion. As of 2018, there were three instruments that had been approved for the Invicta project. The original EIA of 2009, which had a large project. Then an ITS was submitted in 2015, which reduced the scope of the project and converted it into only an underground mining project with a capacity of 400 metric tons per day, and it withdrew many components, including a processing plant. Initially, they had a plant within, and now they removed it. And they had a second ITS, which is a minor change having to do with the ventilation system inside the mine. There's a third ITS that was submitted in August 2018. This ITS, as you know, and as has been discussed, was rejected by SENASO, which is the authority that evaluates such permits. Why? This permit, well, it includes an alternative system for water management at the mine. This system, just so that we're all on the same page, when you have an underground mine, you have perforated, you've created a mine opening, and at that time, if we're by an aquifer, water is going to begin to come out naturally. And as was verified by the OEFA, that is what happened. And the ministry, when it grants the permit for construction, also identifies it. And what it tells the company is, okay, I'm going to authorize you to build the mine, but water is going to come out. Undertake a study of how much water is going to come out and present me a system as to what are you going to do with that water. Are you going to treat it? Are you going to discharge it? Are you going to reuse it? And since it is precisely a component of the mine, before beginning to operate the mine, before beginning exploitation, you're going to have to certify this vis-a-vis the authority. You're going to have to secure an environmental certification. And that is precisely what Invicta did when it included this in the third ITS. It included it to have it approved and to get an environmental certification. Now, here I would like to note something. On the first day, what Mr. Velarde said was that this alternative system had been done at the request of the OEFA. Now, it's true that the OEFA made a request for a corrective measure, but it did so in October of 2018. In August, the system had already been built. So it's not at the request of the OEFA, but rather at the request of the ministry in 2015. That the request that this system be built. Now, what happens here? When you present a study, the authority assesses it, and if it has technical shortcomings or problems, it asks that information be corrected. That's what is known as observations. As you'll realize, they asked that 49 points be corrected in the instrument. 23 of them were resolved, and the other half were not. And I want to highlight one of them, which I think is very important here, which is precisely from the alternative system for water management inside the mine. What the SENACE verified in the evaluation is that this system was already built. In Peru, the rule that exists precisely to avoid and prevent environmental impacts is that before building a component and starting it and operating it, you need to apply for environmental certification. That is the rule that exists. Now, in this case, there is a clear provision in the law that notes that if the authority verifies when it is assessing an instrument that something's already built, then the authority is under the obligation to declare it improper. That means that it must not environmentally certify that component, and that is precisely what happened in this case. That is why, as of October 2018, this system did not have environmental certification. Now, in the initial presentation, it was noted that this information of not being able to build without certification, which is in my report, it's not just, I know this article has been shown here as well, but I simply wanted to note that. And one last point on the ITSs, Mr. Castañeda said in his testimony that it struck him that the ITSs that had been, were considered for, it took 2 months to be considered for approval, whereas his had taken less than 1 month. Well, if you look at the record, the first one took less than 1 month, the second one it took 3 months, so my calculation is more beneficial, and the third one took 2.5 months to be disapproved. It wasn't even approved. So the time frames that I am considering are average and they're reasonable. This issue has been touched on today. That's why I included it in the presentation, which is the pad. What Mr. Bravo said is that I can regularize with no problem my component. And he said that that was very common. In effect, in Peru's history, there have been tools for regularizing components. There have been 2 in the last 10 years, not 10 or 15, as it appeared was trying to be said. The PAD, this instrument, it was approved in late May 2019, and it allowed the opportunity for the mining title holders to fall under this instrument. Number 1, according to the documentation in the record, I've looked at the exhibits, Invicta did not avail itself of the PAD or come under it. You didn't have to go to the field to do so. The first dossier that you have to submit is a very theoretical one, simply stating, in the first 30 days, I wish to avail myself of it. This is the information. And then you have much more information to do so. And second, I repeat, The MEM sought environmental certification, not just presenting the request, but securing the certification. The PAD, in my experience, and I've seen 3 or 4 of them, takes about 10 months to secure approval. So this takes us to a time period much beyond what I calculated for a regular average situation. Therefore, in my opinion, what was pending as of October 2018 was modifying the EIA so as to incorporate alternative system and to incorporate the water sources. And that required dismantling the system because if it was operational or operating, then it wasn't going to get the environmental certification. The estimated time frame I gave is December 2019 to March of 2020 as environmental certification, and that is going to push back the rest of the permits because the environmental certification is the master permit for the granting of all the others. Second group, mining permit. This group, we've also discussed quite a bit. An authorization for construction was sought. It was built, and it was not possible to carry out the supervision, and it was suspended on several occasions. With respect to this point, what I want to say is the following. Mr. Castañeda said I went to the ministry and immediately they would give me my authorization. Well, that is not so. What the authority does is it goes up, it verifies that everything has been built in keeping with what was approved, and in this case it was going to verify that there was a change, the whole alternative system, because it was in mine, and then they ask for any number of documents which are not in the record, whether Invicta, it's not clear whether Invicta had them or not. One of these is the guarantee. In my report, I assumed that Invicta had the guarantee of the mine closure plan, which is a requirement, but from the record, it's not, doesn't appear that they had that. Now, mindful of that, another permit that was pending was precisely the mining permit, which is what enables you to extract the ore from the deposit. Now, for this, one of the requirements finally was to have the environmental certification because, as I've said, the very Ministry of Energy and Mines, what they said was you have to have the environmental certification for the alternative system before you begin exploitation. It is a requirement imposed by the authority, and that requirement was not called into question by Invicta at any time over these years. Now, based on this permit, well, my view is that it could be secured between December of 2019 and March of 2020. And as the final point, in terms of the permits necessary for mining, is water use. As I said, the first EIA notes that there is use of water from a well.
The water usage is not one of the items set out in the counter memorial as requiring an additional permit.
We will have to consult the counter memorial. I wonder if respondent has a quick reaction on that?
Yes, my quick reaction is that claimant is wrong. Of course.
You might give us a reason.
Well, if I may,
please,
Mr. President, the information that was
just as a question, a matter of time. I think it's probably not opportune to take this discussion out of the time for the experts' report. Is that agreed?
Yes, please.
I have stopped the clock, sir.
Well, we could.
I certainly wouldn't like it coming out of our time, sir.
Let's take a little tribunal time for a very brief reaction to why you think this is timely. Arbitrator, different proposes a different way of proceeding. Your view, sir?
I was just going to suggest that this objections are raised and denied. Why not the time risk be on the party who was unsuccessful on that issue?
That's certainly fine by me.
I think we have a problem with the
say it again, why shouldn't the time risk be on the party who's unsuccessful on that issue? Whether it's in or out.
The parties agreeable to that?
Perfectly suitable to me, sir.
Fine, all right. So let's hear the respondent.
Thank you very much, Mr. President. The manner in which the project was presented in the memorial, of course, it included as part of the documents that they had submitted to the government a water system. The source of that water that would be used in the mining project is what changed with the submission of the reply. Initially, under the EIA, the water source was a pond in Humboy. Now that changed with the information that was submitted in the reply. There was no way for the government of Peru to know of that change in the project of Invicta. The expert has attempted to explain the information that was available at the time would not have allowed to reach that determination. The water source, the creeks that are now the source of the new project, as presented in the reply, is an issue, again, that could not have been addressed. Now, our submission is that claimant has attempted to provide an oversimplified depiction of that change, the project, and the water sources. Now, we submit that the expert is best placed to explain to the tribunal what information was available at the memorial stage and what information was then provided at the reply stage that only then would have allowed Peru to respond. So our request is that the expert be allowed to explain those technical issues that of everyone in the room, she is best placed to address. If the tribunal afterwards determines that the explanation does not satisfy or comply with the procedural order that was issued by the tribunal yesterday, then at that moment, the tribunal will be able to make a determination and disregard that information. But such an important issue cannot be reduced to an objection addressed in a couple of minutes and then lead to vital information to be excluded from the record. Thank you.
Well, the traditional approach to this in a matter of this kind would be for the arbitrators to go off and huddle and consult the reply, but I can see that taking a good deal of time. Let me briefly consult with my colleagues how they want to, how we should proceed.
President, I'd like to be heard on this issue if you don't mind. I can make it very brief.
Please.
Our colleague just said that an expert who submitted her report with the reply is best placed to tell this tribunal what information was available at the memorial stage. That's just simply wrong. And there's multiple references to the Royachocha Creek throughout the counter memorial. What they don't say is that we needed a permit to use it.
Well, again, we're getting to a level of detail that is a little bit difficult for the tribunal to deal with in a few minutes' time without repairing to the counter memorial and doing a word search. Now, that's not entirely feasible at this point. Let me pause for a moment and consult with my colleagues.
Before you do, sir, I will also make clear that the section on processing falls within the ambit as well.
Let's deal with that when we get there. Do you mind?
We're in your hands, sir.
right. The tribunal's assessment is that we cannot, in the present context, make an instant word search of the reply to see the extent to which these issues may have been clarified. So I think our ruling is that the expert should continue with this testimony, but the tribunal will consider the matter, the objection that has been raised, and if we conclude on the basis of a fuller consideration that this is out of order, we will simply not, we will not disregard it. And given that we've arrived at this ambiguous outcome, our ruling is for the time required here be divided between the parties. So that's where we are on that. My calculation was at the point when this issue arose, we were someplace around 18 minutes into the report. Is that, can you tell, Madam Secretary?
Yeah, we were at 19 minutes and 33. So 19 minutes and a half of presentation, and I stopped her clock at the time we started the discussion, and I have the separate counts of the parties' time on the discussion. So.
Okay, so she stopped her clock. Sounds so dramatic. Okay, so she has roughly 11 minutes. Is that right?
That's correct, sir.
All right, ma'am. You've heard that mechanical discussion. You have 11 minutes.
Yeah, it's the same in my clock, so perfect.
Brilliant.
Excellent. Thank you very much for that. So I will be a little more quick now. Como estaba diciendo,
As I was saying,
como estaba diciendo,
As I was saying, the original EIA, the one that was approved, indicates that the water is going to be extracted from the tubular well in Wamboy, but in a document that Invicta presented to the OEFA in a sanction-imposing proceeding where they were sanctioned, Invicta indicated that it was going to use the water from three sources. One, Ruraicocha, and there I simply want to note for the record that as regards Ruraicocha, in effect, it is in the memorial, and it's also been discussed in the counter memorial. And to make life easier for the tribunal, I've noted which paragraphs. And another source noted is the Tunanwailaba Creek, and it is noted in the reply brief. Previously, it had not been indicated, but finally, the one permit is useful for the other because it's the same thing because they can be put together. And finally, the other important permit was the water that would come from inside the mine. And here, parenthetically, I would note briefly, the alternative system for in-mine water is not just for treating the water. What Invicta proposed was to use that water, to recirculate it, and to use it in the process. So, any use of water, capture and use, surface or underwater, according to Peruvian legislation, requires a license. It is so established in the general law on water resources and its regulation. What's needed to apply for a license? Well, one, the environmental certification, which we've already discussed, and second, having built the works with an authorization for hydraulic infrastructure. Based on what I've seen and the time frames after the environmental certification for securing the licenses, we'd be talking about sometime between June and July 2020, that is when one would have obtained all the main permits so as to begin mining at the Invicta project. Up until that, so far I've talked about all of the permits for mining. Now I'm going to talk about processing quickly. As the claimant has indicated, there were two alternatives.
I have to interrupt here as well. The objection remains.
All right. Now, we had multiple representations from the claimants that whatever obstacles stood in the way of processing could be readily overcome. Mm-hmm. And it seems to me that is an appropriate matter, subject to the views of my colleagues, that is at least arguably a matter that is appropriate for response in the next pleading. Now, you seem to disagree, so claimant, explain your view here.
I do, because if we look at your ruling, paragraph 7B, it says this portions of Ms. Dufour's report setting out regulatory requirements affecting the ability to begin commercial production that were not referred to in the respondent's counter memorial. You will not find a single statement in the counter memorial saying that we needed additional permitting to do beneficiation or processing.
All right, but how are we to consider the multiple representations by claimant that essentially there was no problem, we could fix the problems on the plants and move right along? Is this not in effect a response to that?
I think we have to take the respondent at its word. And if you look at paragraph 146, it sets out the 3 requirements that they said had to be met in order for us to begin production. That's not one of them. Paragraph 146.
All right, let's hear briefly from the respondent, and then the tribunal will briefly convene.
Thank you. The Malay plant draft agreement, and of course the Malay plant is one of such processing plants that have been invoked by claimant as necessary for them to comply with their obligations under the PPF agreement. The Malay plant draft agreement was submitted with the reply. That is C-287. The documents related to the third-party processing plan, so those were the other plans that claimant had considered, were produced in response to document production and in Castañeda's second witness statement, that's C-420 and C-421. Now, those processing plans were addressed by Peru, so they cannot argue that they were raised for the first time in the rejoinder. They were addressed by Peru in the counter memorial, where we mentioned that there's a need for processing permits, and it's addressed in paragraphs 290, 296, footnote 68, and then problems with the processing at those mills were mentioned in paragraphs 307, 309, 716, 748, 766, and 767. This is not a new issue that was introduced at the rejoinder. Now, we understand claimant's desperate attempt to suppress that evidence, but they're simply oversimplifying. Thank you.
Let me consult again with my colleagues. Just a moment. All right, the tribunal has determined that it will handle this one on the same basis. We will let it in the remaining 8 minutes or whatever she may have, and we will then consider the various citations that have been given us to this issue in the past, to the extent that permitting has in the past been raised, and then we will consider this evidence or not on the basis of that assessment. So that's the tribunal's decision on this matter. But I think if we're going to talk about any issues here, we strike that. We'll handle this on the same basis as the other set of objections.
Thank you very much. Bueno, como estaba diciendo.
As I was saying, now I will be dealing with the permits for the processing activity, as you may have heard, and based on what they indicated, there were two alternatives. One was to use Malay for processing. This is within the Malay property that they wanted to acquire with the transfer contract with Buenaventura, and the other one is through third-party alternatives for processing. As to the Mayay plant, in the reply, we saw the draft contract. The draft contract for the transfer of the unit establishes conditions for the closing, that is the transfer of the unit, and also for the determination, that is when the permits are transferred and the last payment is made. Mr. Bravo mentioned that the only requirement to be able to carry out the transfer was the assignment of the easement contract with the Mayay community. But if we look into the contract, we are going to be able to see that the closing conditions for both parties were about 10 to 12, and based on what we saw on the record, the only one that is thereby analyzed is the one that has to do with the allocation, the assignment of rights for these way, and the second one is not addressed, and these are things that may take some time once again in my analysis, and also for the benefit of Invicta, I have assumed that in March 2019 everything was concluded, but it is important to say that the record does not have any documents that prove that. In addition to this, and I think that this is the most important item that applies to this assumption and the next one, what was going to be processed at these plants? The ore to be extracted from the Invicta project. As we have indicated in the first section, with the mining permits, the closest time that I, in my opinion, as an expert, independent expert, to have obtained all of the permits is July 2020. July 2020 would be the earliest when the ore may be processed in Mayay and also at third-party plants. And in connection with third-party plants, I am not going to go into details. This is in my report. But let me point out that based on the documents that I reviewed for 3 plants, Altagracia, San Juan Evangelista, and Huancapeti II, there is no appearance of them having the permits, and the permits were obtained later on. So much so that I think that I mentioned about a beneficiation concession, and at one point this concession was only obtained in October 2019. That means that they didn't have it before this date. And something that was striking when I reviewed the record is that there were some sample contracts saying, with the 3 plants, saying that the 3 plants had the permits, but when I went to the exhibit sent to me, I went there, but there were no permits. It has been very difficult to review that all of the permits had been granted, and it basically means, based on what I saw, that they did not have the permits. Now, thinking of permits, my conclusion is that mining and processing could have only been started under a conservative view, that is the one that I would have recommended to any of my clients in July 2020. Over the last 4 minutes left, I will try to quickly explain the social license. I know it is a complex concept. I know that it is something that has been discussed, and I would like to just gather some ideas. The social license is a goal for the companies to attain. But this is not only a goal for the mining companies, but this goal is met by applying certain principles and tools. This second portion, and as it is explained in my report, is regulated under the Peruvian regulation, and we will be analyzing this. But I would like to say that literature also establishes, in addition to legislation, that trust is a very important component. Trust and acceptance that is attained between the mining company and the social environment for the project, and it is considered social because the project will have an impact on it. General provisions in Peru beyond the mining regulation indicate that there are some principles to develop these tools, for example, sustainable development, citizenship participation, but the most important point has to do with the regulations of the mining framework. As I mentioned before, for mining, I do need a guideline, and that guideline does not only include the environmental aspect, but a great deal of the social aspect. So it covers the direct social influence area, a baseline to determine who is included, also identification of impacts, and a social management plan that used to be called community relations plan. All of the commitments are mandatory and they need to be complied with as part of the instruments for environmental management. This is a direct social management area that is not modified in the first or second ITS, and as part of this direct social influence, we have the Paran community. And in this drawing map presented by the company itself, we see that there is a boundary problem between Laxanga and Paran. These are some of the ideas that do have an impact on trust. For example, the sanction imposing proceedings that lead to damages, the non-compliance with the community relations plan, and this is one of the tools to be able to obtain the license. And at some point we heard that this should not be taken into account because the project was suspended. In order to suspend a project, you also need a permit. In Peru, we do have a great deal of regulations, and we do not see that permit. So within that deadline, this community relations plan had to be met, and the last sanction has to do with the catchment of water without permit. The company was obtaining the water without permit. And to conclude, I only have 2 slides left, and I would like to answer 5 brief questions. Was it important for Paran to participate in the project? Yes, because it was a social influence area, it was direct influence, it was an important stakeholder, and as you have seen, there were some components, and this is something that has already been discussed, access to Paran on the territory.
I know.
We've disrupted you a bit. If you've got a minute or 2 to finish up, please.
Thank you very much.
The second one is Invicta led to expectations within the community. They may have generated the expectations. In my opinion, the answer is yes, because it was part of the influence area, and it also indicates that there is an access that will be on its land. And since it is the area of influence, Paran considers, and this is also regulated, that all of the benefits and commitments that are thereby established will also be for them. Third question that we have already heard. Would they have entered into any kind of agreement? I have 2 different items. Agreements for surface lands, and here we have the appearance of a component that has to do with the land. One of them is access. From the legal point of view, you need an agreement. As to the social license, yes, the social license is not a document, a permit, an agreement that is signed, but as I mentioned before, there are tools, and those tools, those agreements that are being met throughout time need to be in writing so that there is a measurement of how one is doing or complying or not. Did Invicta comply with their social obligations? Based on the information that I had access to as part of the record, it was determined that they did not comply. OEFA determined that there was non-compliance. There was a late payment of an amount that was agreed in 2017. Here, Mr. Bravo also indicated that, and Mr. Castañeda indicated that that payment was conditioned. There were no conditions attached. It said 45 days, but it was paid throughout a year. And as I said, water was obtained without a permit, and that clearly impacted the credibility and trust. And to conclude, I believe that in this case, we see these significant mistakes.
I think we can probably surmise what your conclusions might be, so it might really be best if you'd end at this point.
Sure.
Okay, thank you.
Microphone, sir.
The usual procedure, you will now be examined by counsel for claimants. There will then be the opportunity for redirect by respondents, and I turn the questioning over to counsel for the claimants.
Thank you, Mr. President. Good afternoon, Mr. Four. Let's begin with the ground rule. Now, the tribunal's ruling and some of the uncertainties that have surrounded that ruling that we just explored creates a slightly tricky situation in the context of a cross-examination, because you have adduced certain annexes to your report that discuss, shall we say, both old and new requirements. And I may want to ask you about components of those documents dealing with the old requirements. Do you understand?
Yes, I understand, but
It was just a simple question, ma'am. And there might be times today when I want to test the methodology underlying your assembly of those annexes as a whole. But I want to make clear to the tribunal and the respondent and the record that in so doing, we are not waiving the claimant's rights with respect to the exclusion of any of the so-called new requirements. Now, Ms. Dufour, in the last paragraph of your report, you say that your report is objective and independent and you have no conflict. Is that correct?
yeah, that's correct.
And you have been a partner at Hernandez and Cia since 2018, correct?
Correcto.
Correct.
And presumably your partnership shares profits like any other law firm, correct?
Correcto.
Correct.
Partner,
I'm sorry, sir, to interrupt, but I know this is going to be an issue because the witness is listening to you in English and then she's answering in Spanish. And when that happens, we need a pause between the two of you because the interpreters cannot catch up.
I think it would be easier than if perhaps the witness listened to me in English on the headphones. I think she can decide
She can
for
decide
herself,
which language
Patricio.
she's going to listen to, Mr. Foden.
Well, it's for the benefit of the interpreters, Mr. Grenet.
I suggest you make a pause then.
All right, how best do we solve the mechanical problem that we have here? Secretary, do you have, what's your suggestion?
They just need to make a small pause.
When Mr. De Rosa was cross-examining earlier, there are ways in, so if Mr. Ford, for example, looks at the transcript in the language in which she is not listening, then she will know when the interpreters have stopped. And the same for Mr. Sorry,
Foden. It's all right.
I'm sorry.
No one
Mr.
remembers my
Foden.
name.
All right, so everyone will keep an eye on the transcript and will not begin their next answer or question until the transcript stops rolling. Is that agreeable all around?
Sure.
Excelente.
So, if a partner, for instance, in your firm's banking and finance department, brings in a big mandate that generates significant fees, all the partners are going to share in those fees, correct?
Sí, pero yo he sido contratada.
Yes, but I was hired. What I was saying is that in this case, I have been hired as an independent expert on a personal basis.
How did your partners react to that?
No han tenido ningún problema.
They have not had any issues because I have explained to them that it was an important opportunity for me, and usually I have worked this outside my business hours.
So you can make profits for yourself that you don't contribute to the partners applying your legal expertise.
Sí, correcto. Por ejemplo, en el estudio también
Yes, for example, within the legal firm, we do have, the law firm, we do have partners that have their direct income. Interpreters are 2 seconds behind her, so she continues to answer at the same speed. I mean, she answers directly. We do not have the 2 seconds we need for us to finish. We can finish, but the court reporters cannot transcribe what we are saying. We are occupying the channel that they need to write on.
Problem. Let's keep an eye on the transcript and do not begin to speak until the transcript stops rolling. Let's see if we can make that work.
Ma'am, because you're speaking Spanish, you would need to look at the English transcript, and when that stops rolling, that's when you would start answering.
Gracias.
Thank you.
And Ms. Dufour, your law firm has a procedure in place for running conflicts checks, correct?
Correcto.
Correct.
As in Chambers, Partners, and Legal 500 for both mining and environment, correct?
Correcto. Es información pública.
Yes, that is public information.
I don't have the Legal 500 on record, but I looked at it.
Sorry, Mr. Foden. I can see the interpreters. I let me see. Count 1, 2, 3 before once Mr. Foden finishes the question. You have to count 1, 2, 3 in your head before you start, because it's just overlapping, and then the record, neither the audio or neither the transcript are going to be able to reflect that if we keep overlapping. I apologize.
Legal 500 on record, but I looked it up. I looked up your firm's profile, and I can't help but notice that the Republic of Peru is listed as a key client of your firm in 2 different locations, correct?
I am not certain. I know that the law firm has advised the Republic, but I would like to state that to date, there is another partner that is an independent expert against the Republic.
Now, according to the Legal 500, your firm's mandates for Peru include advising it on a $5 billion sovereign bond issue in both the U.S. and European markets, and handling 2 ICSID cases. Were you aware of those engagements when you prepared your expert report?
I know that the law firm has advised as local counsel the Republic of Peru. I do not have the details on that case because I have not participated and I have not been part of that, of the area, and the area that I lead has not been part of that, and that is the mining area.
What about the bond issue?
Tampoco.
Not that either.
No tengo conocimiento.
I have no knowledge.
You didn't know that your law firm was handling the issuance of a $5 billion sovereign bond. 1, 2, 3.
Thank you, Mr. Foden.
What I have said is that I know that the law firm has been local counsel of the Republic, and I have also said that I do not have the details. This is the second time I say the same thing.
Respectfully, ma'am, it's not. I'm not talking about acting as local counsel in ICSID cases. I think you need to listen to the question. The question was about the bond issue, which was from 2021, while you were a partner at the law firm. How many partners are there in your law firm?
20.
So you're going to tell me that you didn't know that 2 years ago, one of those 20 partners was handling a bond issue of that magnitude?
Sí, le estoy diciendo eso.
Yes, that is what I'm telling you.
And you realize that the 2 cases that you referenced, the ICSID cases, are currently pending?
I did not refer to them. You mentioned to them, and no, I do not know about the status of those cases.
Ms. Dufour, how did those 3 engagements manifest themselves when you ran the conflicts check for this mandate as an expert?
Cuando hice la consulta para ser yo experta independiente,
When I did the consultation to be an independent expert, there was a comment that there were some cases and it was verified by means of the conflict committee. I'm not a member of that conflict committee, that in this case, there was an independent expert on a regulatory issue. To be an independent expert on a regulatory issue would not mean a conflict.
Did you review procedural order number 1 as part of your mandate?
podría por
Could you please show it to me to review?
No, I asked you a question if you reviewed it.
no sé
I do not know what rule you are referring to. That's why I'm asking you to see it to be able to confirm.
Well, I'll tell you that Article 15 of our procedural order number 1 incorporates the IBA rules of the taking of evidence in international arbitration as guidelines. Are you familiar with those rules?
puede por favor
Would you please show me that to review?
Are you aware of the existence of the IBA guidelines? It's a question of existence, not text.
I am aware that they exist. I am not very aware of the contents. This is the first time that I participate in an international arbitration.
But you say in your CV that you have experience in the mining sector relevant to the potential position for participation as a mining expert in international arbitration. Does that mean that this part of your CV was simply aspirational?
puede por favor poner esa parte.
Would you please show me that portion?
I'll have to come back to it. One of my colleagues will certainly pull it up. But in the meantime, I'll come back to the guidelines
Okay.
on, yes, so there you go. Now, does this expression just simply mean that you were aspiring to be an expert?
No. Pueden por favor
No. Would you please show me the Spanish version? There is a problem here with the written translation.
experiencia en el sector
It says experience in the mining sector relevant to the potential commissioning for participation as a mining expert in international arbitration. Here I was asked to issue a regulatory opinion. Then what I am including here is my experience, regulatory experience in Peru, to see if that qualified to be able to have this task. Here, I'm sorry, I'm not saying that I am an expert in international arbitration.
No one said you were an expert in international arbitration. And the translation, despite the fact that I don't speak Spanish, says effectively exactly what I asked you. Is that part of your CV simply
Yes.
aspirational? Wait till I finish asking the question. Is that part of your CV simply aspirational?
No es aspiración.
No, it's not aspirational. Here I'm saying what my experience is as to regulatory issues in Peru to see if I can comply with this request or not. I do not understand the doubt here.
What request are you talking about?
I did not understand your question.
Have you ever served as an expert in international arbitration before?
No.
It's the one
No.
on your CV.
Señor Foden, acá
Mr. Foden, here it says experience in the mining sector relevant to a potential participation. I was asked whether I had regulatory experience in Peru.
To include that in your CV then?
No entiendo por qué.
I do not understand why you're putting words in my mouth. No, the answer is no.
Legislation says that you were asked whether you had regulatory experience relevant to arbitration. Who
No.
asked you?
No. Vamos en-
Okay, let me read this again to see if we are able to understand each other. Could you please show the Spanish version and not this version, please?
I'm the only.
I'd love some help,
I'm the only
please.
non-Spanish speaker, but I do speak the English language. But I think you can rely upon the tribunal to look at the point that you
Yeah.
obviously are making.
Certainly.
Inform the view as to the proper interpretation, and it's our view on interpretation that counts rather than as witnesses.
Indeed. So, Ms. Dufour, perhaps if you haven't served as an expert before, I can tell you that there are these things called the IBA rules on the taking of evidence in international arbitration, and they serve as guidelines under the procedure of these proceedings. They're not rules, but they're guidelines.
Okay.
Do you understand? And
Okay.
pursuant to article, I'll read these rules to you. If my colleagues across the room want to tell me that I got them wrong, they can come do that. But I'm not going to pull the document up. It's not part of the record. It's incorporated by reference. And pursuant to Article 5.2a of the IBA rules, an expert's required to present a statement regarding a present and past relationship with one of the parties. But you made no disclosure in these proceedings of your present and past relationship with Peru, did you?
That is correct, because I have not had a present nor a past relationship with Peru, as you indicated very well. At any rate, Hernandez is the one that has had it, and I was the one hired. I had never provided services for the state in the past. As I said, this is the first time that I have participated in international arbitration.
So in your presentation, the second line is that you're a partner at Hernandez and Cia Abogados. You've already told me that you share profits with your partners in that law firm, and that law firm has represented or is representing Peru in 3 different engagements. And now you're going to tell me that you have no relationship with the Republic of Peru. How do we get there?
I do not have it. I do not have any relationship with the Republic of Peru.
Do you get profits from Mr. Hernandez's fees generated and paid by the Republic of Peru? Do you share in those profits?
Yo lo que recibo.
What I receive are the proceedings for my participation in Hernandez. That's what I receive, those profits.
And you don't think that forms a relationship with you and the government?
No, porque si no,
No, because otherwise I would have relations with all of my clients, and that's not the case.
They're firm clients, ma'am. You're part of the firm. You're part of the partnership. I need a verbal answer.
soy socia del estudio.
I am a partner of the law firm, indeed. I do have a stake there. That does not mean that I have a relationship with each one of the clients of the law firm. Again, in this case, the engagement was done in my personal capacity as Ms. Dufour.
In Peru, does a lawyer have a professional ethical obligation to act on behalf of a firm client's best interest?
Ethically, of course, yes.
And you also have a duty of independence to this tribunal, don't you?
Yo tengo.
I do have a duty of independence vis-a-vis everyone here because the engagement has been as an independent expert. If you had hired me to...
You had a duty to the tribunal.
Sorry, can I
No,
finish my answer?
I'd like to ask my next question,
No,
which is, do you
Mr.
not
Mr.
see a
President.
tension?
But the expert is asking for an opportunity to respond. I respectfully request that the tribunal make a decision whether she is allowed to respond.
I suggest, gentlemen, that this kind of sparring on this sort of matter is not very helpful in this context. Let me just clarify. Ma'am, how do you view your relationship to this tribunal?
Independent, and also independent with all the parties. If I had drafted this report for Invicta, I would have put every exact word.
Right. So your testimony is that the fact that your partner, a partner in your law firm, may act for Peru, in your assessment, has no effect on your independence or your report. Is that correct?
That's correct. That is my answer.
And so it's for the tribunal to assess whether we accept that or not.
Exactly.
All right. Why don't we move on?
I'd like to ask you about the instructions that you were given for your report. Now, we've talked about those IBA rules, and Section 5.2b of those rules requires you, in your report, to include a description of the instructions pursuant to which you're providing your opinions. You didn't include a discussion of any such instructions in your report, did you?
Voy a revisar.
Let me review. Paragraph 2 of my report. This report, this legal report, is divided into two sections. The first section analyzes the regulatory aspects. Paragraph 3. The second section is an analysis of the social license. That is the engagement that I've had.
Was that what Peru instructed you to opine on?
El pedido.
The request that I received from Arnold Porter was to prepare an independent expert report that analyzes regulatory aspects of the Invicta project and the social license. That is the request I got from AMP.
And you're aware, ma'am, that Peru relies on your report to show that absent the blockade, my client would not have been ready, and I'm quoting from the rejoinder here, paragraph 311, would not have been ready for lawful commercial exploitation until, italics, July 2020, more than a year and a half after the start date of the claimant's repayment obligations to PLI Huara. My question is, did you know that this was the purpose for which Peru was going to utilize your report?
La primera vez que fui contactada por Arnold y Porter, lo único que recibí.
She needs to start again.
You have to start again. You really have to take a pause.
Ma'am, we had an interpretation and overlap issue there, so we need to have a little pause. And do you need the question repeated?
No.
Okay, let's give your answer again, please.
When I was hired by AMP, and I know that I was not the only Peruvian lawyer that was contacted, a number of lawyers were contacted and were assessed to see whether we could do this engagement. What I was asked to do, in a very objective manner, was the following. Can you examine the regulatory situation in this case, and can you examine this concept of social licensing? That's the only information that I received, and a number of documents were provided to me. At the time, I did not have a lot of information about this case. We held a conference call with AMP, and with the information that I had, I made general comments, and I said, okay, I was suitable to conduct a regulatory evaluation because that was part of my expertise. And also, I could assess the social license because that's also part of my expertise. And that was what was told to me, and that was the basis of my engagement. And on the basis of that, I prepared my report.
Well, we'll certainly come to that on the social license, but I wanted to know, at paragraph 144 of your report, actually, I think that's in Spanish. It's paragraph 143 in my English. You make reference to a footnote in a document it's a draft of the PPF agreement with Pandian, and it's in tab. But I happen to notice that you don't actually cite that document in your list of annexes.
A ver,
Let's see.
I ask a question, which was a poor question, admittedly. Now, you refer to the draft agreement of the PPF, but not the actual agreement. Did you at any point see the PPF agreement?
I have seen the document later on, and in connection with the draft I am citing, the portion that I review is the annex on permits. Unfortunately, in the case file, we didn't have a lot of information of the permits that Invicta has had and which ones were lacking. Here at Annex H, you can see the ones that were obtained to date and the ones that were lacking and which ones were relevant for regulatory issues.
Just asked if you'd seen the amendment. Can I now take you to tab 5 in your bundle, please? When you looked at that PPF agreement, did you only look at the sections dealing with regulatory approvals, or did you look at the timescales for repayment? What we have here on the screen, and I'll just let you know what this is a slide from the opening. And you were present for that opening, correct?
yes.
Now, my question is, when you looked at the PPF amendment, did you look at the timescales for repayment, or did you focus only on the regulatory section?
I have looked at a number of permits. I have looked at a number of documents, excuse me. I have seen these documents and these timelines, but this has had no impact on my report or any relationship with my report.
I didn't ask you about its impact on your report. Sorry, I haven't asked a question yet. I just asked you if you had looked at the timescales for repayment under the PPF agreement. Have you?
Yes.
Now, if you look at the screen on the next page, you can see that the draft amendment to the PPF agreement anticipated that the Malai transaction would be completed in November 2018, and the first gold repayment to Pandian would take place in September 19 after a 9-month grace period. Do you see that?
Yes, but esto yo no lo había visto antes.
I hadn't seen this before.
You were here on Monday, correct?
Sí.
Yes,
So you weren't looking at the screen when this was up there.
No, me refiero.
I'm referring to the documents, the drafts. This I had not seen.
Ma'am, you rely on this document in your report. Not this slide, the underlying document.
Creo que mi reporte es muy.
I think my report is very clear when it says that I have relied on Annex H and no other sections.
Where does it say that?
Ciento 144.
144. That's the most recent statement by Invicta that identified the documents of the case in connection with this component, hydrocarbons, is the one in Schedule H of the draft that we are speaking of.
Did you look at the whole draft amendment, or did someone from Peru's legal team just hand you that Section H?
No, yo sí tuve acceso.
I had access to the whole document, but I focused on Schedule H.
So you didn't see the schedule for repayment then?
Realmente no.
No, I do not recall having seen it. I focused on permit-related matters.
So if we look at the 9-month grace period, in line with that, since Lupaka obtained Malay's community consent to proceed with the Malay transaction in March 2019, would you agree with me that the first repayment obligation would have been due in January 2020? It's on the table. I can represent to you that's what it says. Do you see that?
Mm-hmm.
Now, again, I'm not sure what your calculation of the timeframes are following the tribunal's ruling, but at paragraph 189 of your report, you refer to what you call an optimistic scenario for the start of mining as early as December 2019 and the start for processing activities as early as January 2020, correct?
Disculpe,
Excuse me, Mr. Folder. I did not answer the question you asked me.
es cuando usted me
That's when you asked me whether I was looking at the document. I said, yes, I'm looking at the document, but I haven't responded to your question.
Okay, we'll go back. Do
Gracias.
you see on that table in front of you when the first repayments are due?
Yes, but I think that here this is based on an incorrect premise. Here it is said that in March 2019.
You saw them.
I believe she was giving an answer, was she not?
Thank you. Como estaba,
As I was saying, I think that this document is based on an incorrect premise. Here it is said that in March 2019 the consent would be received. As I explained in my presentation, the assignment of the contract with the community was a requirement for the closing. But there were other requirements that have not been assessed or evidenced in the file. I don't know if this is another document or not. I cannot talk about a presumption that doesn't have any kind of merit. Excuse me.
Man, we all know what your case is on the permits, and we will come to them. Trust me. For now, I'm just establishing that the document set out a repayment deadline, first repayment deadline of January 2020. And we agree, can we agree that the Malay consent came in March of 2019?
no,
No. What happened in March 2019 was just the assignment of the servitude of the easement of the Malay community. It was only the assignment of the easement of the Malay community. That was the only thing.
Well, frankly, that is not an issue that's been in dispute so far as I'm aware, that the consent was given in March of 2019. But it doesn't matter. For purposes of our discussion, I just want to establish that your optimistic scenario has the start of mining activities in December 2019 and the start of processing activities in January 2020, right?
ese escenario optimista
That optimistic scenario, as stated in my report, does not consider the water use permits of the stream that Invicta needed for mining purposes. Consequently, the conservative timeline, the real timeline, would be between June and July 2020. That's what I said in my report, and it is clear that Invicta needed to use the water, so much so that it was using the water without a permit.
I understand your submission, Ms. Dufour. So let's take your optimistic time frame. We don't need to talk about your conservative time frame. We know you do want to talk about it. But on that optimistic time frame, and looking at the table that we had out, the repayment obligations would have been made, maybe with a month lag time, on your optimistic scenario. Do you agree?
I agree, but without any use of water. There wouldn't be any use of water.
And you know that Pandian, as a lender, because I know you work in commercial actions as well, as a rational economic actor, they'd wait a month or two, likely provide forbearance if maybe add some penalties and interests if we were perhaps a month late making those repayment obligations?
No es materia de mi.
That is not part of my report. I have not looked at that information in detail. Consequently, I cannot give you an answer to your question.
Fair enough. Now, I want to start our discussion about the regulatory process with a general chat about the various approaches that you take to regulatory deadlines, and then we're going to come to what we consider to be the three outstanding matters. At paragraph 22, you refer, and I heard you say this in your presentation, to the difference between the legal time frame and the real time frame that's required to modify relevant permits, correct?
Es correcto.
Correct.
And you explain that the legal time frame, and I'm using the English here, is the term that the regulation establishes for the procedure of the permit, whereas the real time frame is the term that in practice, i.e. on average in reality, it takes to carry out this type of procedure, correct?
Correcto.
That's correct.
Now, Ms. Dufour, would you agree with me that the administrative procedure in Peru, as a general matter, is governed by the Law on General Administrative Procedures, number 27444?
Correcto.
That's correct.
And you make no reference to that law anywhere in your report, correct?
Debería revisarlo.
I should look at it.
That you do not, and on redirect, my colleague might want to take you to it. Now, I'm curious, though, taking my representation, why would you provide a legal opinion on Peruvian regulatory law without making reference to the administrative lex generalis? Doesn't it make sense to start at the wider area and then narrow down on the specific?
A ver,
Let me explain. We have specific laws in Peru in connection with certain matters. In this case, I have relied on specific legislation. When the lex specialis doesn't really have regulations that are applicable, you apply suppletorily the more general rule. What I have done is to apply the one that imposes no problems and is within the legal framework.
So I'm going to read out some provisions because you didn't include the general administrative law as an attachment to your report. You can tell me if you think I've got them wrong. So Article 66 deals with the right of the administered. It says the following are the rights of the administered with respect to administrative procedure. And at subsection 7, it says the deadline set for each service or administrative act to be complied with and to demand compliance from the authorities. The next one that I'll read is Article 142, which says the mandatory nature of deadlines and terms. And at 142.2, it says all authorities must comply with the terms and deadlines under their responsibility, as well as supervise that subordinates comply with those at their own level. It is, at 142.3, it is the right of the administered to demand compliance with set deadlines and terms for each service. So my question to you is very specific, Ms. Dufour. Does my unofficial translation reflect what the law says in essence?
es correcto lo que ha leído.
What you have read is correct. I also have to say that, as I explained in my presentation, if the deadlines are not complied with, the administered parties has a remedy, which is to put forth a challenge. I have looked at all the permits in the Invicta file. A lot of them have gone over the deadline, and I have never seen Invicta issue a complaint or some kind of challenge. In all of the cases, it has waited for the authority to rule on this, and it has gone beyond the deadlines included or provided for in the law.
I accept your submission, ma'am. But the provisions that I just read are mandatory for every administrative deadline that you've described in your report, correct?
Es correcto, pero como digo,
That's correct. But like I said, in that case, the administered party is the one that has the possibility of applying for a remedy. The administered party is the one that can do it or wait until the authority rules on this, as Invicta did in connection with all of the prior permits that it processed.
So when you talk about your, quote, real-time estimates, you're referring to the fact that the Peruvian agencies frequently do not meet their own legal requirements under the general administrative law, correct?
Es correcto.
That is correct. What I've said is that I have used deadlines in general practices as used by the mining industry, and that in my experience, that's the correct thing to do when you are trying to establish a permits strategy.
And so, effectively then, the timeframes that you refer to as real are just as accurately illegal timeframes. So what I want to know is, when a foreign mining investor goes to raise funds or makes an investment, enters into a loan agreement, you're saying that they don't have the right to look at the law to determine what those deadlines should be relevant to that agreement. Is that your submission?
Acá creo que tengo.
I have to clarify two things here, I think. This is the second time in this arbitration that I hear people saying that the deadlines I've used are illegal. That's incorrect. I have used average deadlines, and I have said that there are certain deadlines provided for in the law, and if they're not complied with, the administered party has the possibility to deem that permit as rejected and therefore bring an appeal. That's important to state. These are not illegal deadlines. Please repeat the second part of your question.
So, effectively, if a foreign investor invests in Peru and they want to know how long it's going to take them to get a certain permit, they have to hire you to know what the deadline's going to be? Is that right?
No exactamente.
Not exactly. They could also go ahead and verify the deadlines. The approval of permits, that's public information. You can go to the web pages of the different agencies and see how long the agencies take to approve the permits. Yes, in general, many of the mining companies, or the foreign mining companies coming to Peru, hire a lawyer. But many of them work in-house, and what they do is to verify, on average, how long these things take. And then on the basis of this, they conduct their programming. And that is what I would recommend any investor to do.
Now, I hope you'll indulge me for a moment, Ms. Dufour, and we explore the timelines that you say shouldn't apply, the legal timeframes. But if you're wrong, and Peru could be trusted to abide by its own laws, I want to talk about what the deadlines would have been for this project. Can we agree to proceed on that basis?
A ver, como he comentado,
If the legal deadline is used, it's not that the permit is deemed approved. In that case, the administered party may present an appeal for challenge. That takes time, and then to submit that challenge to the same level, that would be a reconsideration, and then new evidence should be submitted, or it could issue an appeal, or rather bring an appeal to go to the higher level. In my experience, that takes longer than the average timelines. If you're asking me to take the consolidated text deadlines and to take those deadlines as compliance, that would be illegal. But because, like I said, the administered party may deem that the permit has been rejected and not granted.
Ms. Dufour, I know that you're a professor in the Faculty of Law at a university in Peru, but we don't need to lecture on this process. The question I asked was much more simple. Could you and I go through an exercise in which I ask you about deadlines under the law?
creo.
I think that exercise cannot be done because it would be completely and absolutely hypothetical. You are asking me to assume a number of hypotheticals, to take a legal deadline and then to see how long the company would take to prepare documents to lodge an appeal and then to go and do another hypothetical to see how long the higher authorities would have taken to solve that issue. I think that what you are asking me to do is a hypothetical on a hypothetical. I don't think that this adds anything in this case.
That's very clear. But let's look at the slide, the first slide that's at tab 5. So what I need to understand from you is that maximum legal time frame. Those just have absolutely no relevance, except for the few times in your report where you do say they actually meet reality. Is that right?
Lo que estoy diciendo
What I'm saying, once again, is that one reaches this deadline established in the law, the administered party may decide to consider the permit denied and can then appeal. It cannot consider it as approved.
Right. So basically it's not the deadline because you always have to add an appeal and you have to wait for the appeal to be heard, and then that would be the real timeline, basically, if you were to abide by the law.
si uno quiere seguir las
If you want to follow the rules that are established in the law, if there is negative silence, as in these cases, and if you get to the maximum term, then what you can do is file an appeal. And this is not just the last year or 2 years. These are the general rules that have existed for a long time. And it's one of the first issues that investors who come to Peru check on. What are the applicable rules when it comes to permit approval? As I say, this maximum time does not mean that the permit is approved. It means that the administered party may assume that the permit is denied and then move on to the next level.
Let me interject here for a moment, if I may. I think it's going to be necessary for us to take our 10-minute break. Let me also observe that heretofore this hearing has always been conducted with a high level of courtesy and professionalism. We've certainly had our moments, but I think generally it's been conducted at a very high plane. And I hope we'd be able to bring it to a conclusion on that note. Let's reconvene. We'll be back in 10 minutes.
¿Puedo salir a agarrar algo o no? ¿Sí puedo?
See, are we all ready? Claimants seem ready. The expert is ready. The transcribers are besieged. Interpreters are besieged. We're all feeling Friday. All right, let's return to the cross-examination.
Thank you, Mr. President. I just have one final question, Mr. Four, on the legal timeframes. Your view of them, let me make sure I have this right, assumes that there's either no response or there's a rejection. So an appeal is always going to be necessary. Therefore, it's better to just wait until you get a first instance decision. Is that my understanding of your position? Is that correct? Okay. But after that deadline passes, the applicant is effectively just waiting for some arbitrary period that, unless they have consulted you and your crystal ball, they aren't going to be able to know when they will actually get clarity from the relevant administrative authority. Is that right?
No, that's not right, because los tiempos por
The average times that I have considered are not arbitrary times. They are times that have been obtained mindful of how long it has taken the authority in similar procedures and what has been arrived at as an average. Even when it comes to modifying the EIA, I consider a term of 7 months, even though the last two experiences I've had, one mine in Cajamarca and another in the south, have had longer terms. But what I have done is to have an average time between 2017, 2019, and the approvals that have happened. So it's not arbitrary. It's something that I've constructed based on available information.
Let's talk about the methodology behind that construction.
Claro.
So, at paragraph 23 of your report, you explain that the basis for the determination of what you call the real-time estimates is a review that you undertook of administrative procedures for similar permits obtained by similar permit holders between 2017 and 2019. So my first question is, are we to understand that MD 0002 is a review of all administrative procedures for similar permits across the entire country of Peru during that time?
No, no es correcto.
No, what you are saying is not correct. What I'm saying is that I have worked on all the records to which I've had access.
So these timeframes are based on cases that you handled personally?
No.
No.
Transcript just said, what I'm saying is that I've worked on all the records to which I've had access. So that's where my confusion comes from.
No hay problema. Lo que dije en español
No problem. What I said in Spanish is that I have taken into account the procedures to which I've had access because they've been a matter of public information. And in addition to that, what I've done is check, based on my experience, whether those times are reasonable. As I say, in many cases, the average, based on this exercise, which is not a statistical exercise, are less than the authority has taken of late, and that it has taken even in the Invicta case. And there I cited the example of the ITS. I considered an average time of 2 months. Nonetheless, of the 3 ITSs that have been considered, one took a month, another 3 months, and the other 2.5 months, even taking into account just the average of the ITSs in the case of Invicta, we would have a time longer than what I considered.
Citation of the methodology. So, but you would agree with me that you don't set out in your report the criteria upon which you pick the permissions that constitute your exhibit MD002.
Let me check quickly, please.
Is at 7, Mr. Garibaldi.
Mr. Foden, could you tell me the paragraph you're looking at to make my review simpler and quicker?
I can't because I couldn't find the criteria in your report, ma'am, and that's what I'm asking you. You told me
Acá está.
a few moments ago.
It's right here.
Sorry, it's not a statistical exercise, and I'm trying to understand the nature of the exercise. What criteria did you apply in selecting the permits that populate these 14 categories?
Can I read the relevant part? It's paragraph 23. The last two sentences note the real times for the getting permits in this report have been calculated based on the review of administrative procedures of similar permits obtained by title holders from 2017 to 2019. The result of this review is found in Annex MD0002. And I also include a footnote where I note that on an exceptional basis for the permit on hydric availability, I've taken a longer time because in the period analyzed, there were permits with very lengthy times, which would have the average be higher than what I've seen in my experience, which would have gone against the timeline for evaluation.
I'm glad you brought that up because I did want to come to that, but I have to start with the question that I asked you. Is it your evidence in front of this tribunal that the criteria that I asked you for is the word similar? You just looked for something similar, but you don't define what is meant by similar here, do you?
Similar.
Similar in Spanish means that it's the same, and so a modification from that, what I've sought are other modifications from that. In the ITS, I have taken other ITS approvals and so on.
But not all of the ITS approvals that are publicly available across the nation during that time period. That's what you told me, right?
Lo que le he dicho es
What I said was that the ones that I've had access to are the ones that I've taken into account. And I would like to add, as I said at the outset, I work in planning of permits for the last 16 years. I have quite a bit of experience in terms of how long these procedures take. And as I say, in those situations that I saw where there may have been some sort of irregularity in that the time was much longer than the regular, what I've done is to remove them so as to not have a negative impact on the timeline for Invicta.
Would it be fair to say then that the criteria you apply is your experience and your judgment?
diría que ese
I would say that that is the main criterion, but that in this case, in addition to not be the only one, I supported it with a benchmarking of the permits during that time and the permits to which I had access.
But there's no sort of national survey of these timeframes that you could rely on?
Let's see. Most of the agencies do have a unified registry. For example, the ITSs, in theory, should be found in the same system. It's not that they're separated out by region, so the ones that have been available are the ones that I reviewed. That's why I was saying that if you look at this annex, you're going to see that there's a project in Arequipa, just as there's also a project in Cajamarca.
So coming back to your footnote 12, you say, exceptionally in the case of water availability permit, I've considered a longer time frame on the basis that you could not find many permits that had a fairly extended period. Now I wonder, Ms. Dufour, can you tell the tribunal how many administrative resolutions you excluded from your sample on the basis that they didn't meet this so-called fairly extended period?
Una,
One.
sí.
But you don't.
One.
No, pero lo estoy contestando ahorita.
But that's what I'm answering right now. One. And also, if the tribunal would like, I could make a copy so that you can see that in this case, the time was extended a great deal in relation to the average for similar procedures. And that's why, for the benefit of Invicta, and to make this evaluation as objective as possible, I removed it so that there would not be an impact on the timetable.
And you don't define fairly extended term, but that's the criteria that you applied for lengthening the time scale, correct?
No,
No, to reduce it. To reduce the time scale.
So you increased the time scale from 2017 to 2021. That's what you say. And you do that because you only found a few that didn't have a fairly extended term. But at no point do you explain what is meant by a fairly extended term, nor do you say why that should have any impact on the range of decisions that you've considered, do you?
If you turn to point 8 of the annex, which is this permit, there you see the details on the resolutions. Had I taken into account only 2018 and 2019, I would have had only 3 permits, and the time would have been much longer. So what I've taken are resolutions from 2020, 2021, and 2022, and what that has done has been to finally reduce the average and bring it closer to what I, in my experience, have seen in such procedures.
So let's look at item 8. You include 8 administrative decisions in item 8, correct? Whereas at item 10, you include only 2 administrative decisions. Now my question is, why were you satisfied that 2 administrative decisions was representative of that category, whilst you needed 8 to be representative of the accreditation of water availability?
sí, no hay ningún problema. Contesto la pregunta.
Yes, no problem. I can answer that question. In the case of water availability, as I say, it wasn't necessarily because of a number in the sample, but rather the procedures that were in that sample were not representative, and they would extend the period. Whereas in the case of water use license, on the other hand, these resolutions of 2018 and 2019 coincide with the times that it generally takes to get to the last stage of water use, which is the license.
Nuevamente,
Once again, I repeat, the main criterion that I have used is my experience.
No description of that sort of delineation that you just provided in MD 002, is there?
no hay mayor detalle.
No, there's no greater detail.
I'm sorry, sir.
Sorry.
We didn't catch the answer, so we need the pause.
No hay mayor.
No, no greater detail.
You don't define what is meant by a fairly extended term, correct?
Correct. But, as I have offered, if necessary, I can present the resolution to the tribunal so that it can make the comparison of the extended time that that resolution had.
Now, I think you mentioned this earlier, and you said that at footnote 5, you explained that the actual average for the now irrelevant item number 9 is 4 months, but then you generously, towards my client, adopted a 2-month average period instead, correct?
Can you repeat which footnote you're referring to, please?
5.
Del documento, no del...
Of the document, not the report.
Read it, I believe.
No, no lo he leído.
No, I did not read it. Correct.
Appreciate that you're being generous to my client with that particular category, but the approach there seems to be that you selected a subset of 3 licenses and then excluded a third of them based on an undefined notion of unrepresentative, correct?
Once again, in this case, when I say it's not representative, what it means is that it has a much longer time than what I've seen in my experience.
Now, you also attach a Gantt chart to your report at MD0032. It's at tab 8, but I think it's probably more helpful for you to look on the screen because, unfortunately, we didn't print this out in color. I wanted to ask you a few questions about it. Now, this has been drafted using your real-time estimates, correct?
ND30.
You can look on the screen then.
No, I have it printed.
Okay.
Don't worry. Yeah. I knew
You brought your own exhibits?
I brought the same exhibits.
Let me just ask the question again. This is based on your real-time estimates, correct?
Correcto.
Correct.
And if I check the metadata in this Gantt chart, who would tell me assembled it?
With certainty, I am the author, and I am the one who presented it.
What's the name of the software program you used to prepare it?
Again,
What's the name of the software program that you used to assemble it?
Project.
project.
And what construction expert did you consult when you determined the construction timeframes that are set out in green?
Once again, in this case, I used the experience, for example, how long it takes to build certain components. If you take a look, I considered an approximate time for constructing mining facilities, again, based on my experience. Could it take longer? Yes, correct. But these are the times I use for this type of data.
But you're not an expert in mine construction, correct?
Correcto.
Correct.
Now, there are some other areas where you give opinions on matters that I thought perhaps weren't necessarily legal. So if we turn to paragraph 163 of your first report, I'll read as you catch up. You say, even if production had started in October 2018 with the material mined during development and preparation, such material would not have been sufficient to supply the processing plants for more than 1 month. Now, I'm curious, why would a regulatory expert make an observation about how long IMC could process ore for, Ms. Dufour?
Sorry.
163 of the Spanish version says something else.
57.
Sí.
I have paragraph 163 in the English, excuse me. In Spanish? Yeah, in Spanish it's 163 as well.
Página 52.
Page 52.
Yeah. So my question is, why would a regulatory expert provide any observation about how long IMC could process its ore for?
A ver, me voy a explayar.
Let me elaborate a little bit on this. Those of us who work in mining and in the regulatory area, as time goes by, we start having some experience not only in legal issues, but also in some technical issues. I wouldn't say at the level of an expert, but we get to know the same way I gave you the example about the aquifer and the mine access. It is the same situation here. So I consider that my statement here is not beyond what I could say in a report, or is not irregular.
Sure.
We have limited time here. I realize my questions aren't always very articulate, but I'd be really grateful if, in respect of that limited time, you can keep your answer to what I've actually asked you. And what I asked you there is, why did you include it in not your report? Not whether you have the ability to comment on processing times, because frankly speaking, it's not the most complicated maths. But it has nothing to do with what you told me your instructions were. Why would you comment on whether IMC could continue to supply ore to Malai?
Gracias.
I thank you for the specificity. I don't think I understood the question very well at the outset, and as you said, I had to look into regulatory issues, and as part of the documents that I received a report that was issued by MICON, and this report is of a technical nature, but it is based on some regulatory premises. One of those premises that MICON poses is that it would have been possible to initiate exploitation in September 2018. And they also say that there was stored material to begin processing. Now, the paragraph that I mentioned here that has to be read in connection also with the previous one that refers to MICON and also the premises, it also refers to that. That is, the permits were not available, and the material that was stored, if there was a plant, the maximum was for just the processing of a month worth of work. So this is based on the premises in MICON's report, the ones that I assessed.
I understand that. I have one last question on this point. We're both agreed. You comment on whether they could have used that stockpiled ore for commercial production. You say from a regulatory perspective they could not. That's in 162. But then, for a reason that I still can't understand, you go a step further and talk about how long they could have supplied the Malai plant for. Can we just agree that's opinion that probably should be left to the likes of MICON rather than a regulatory expert?
No, porque es.
No, because it is exactly a comment on MICON's premise in a regulatory issue. I do not understand why I wouldn't be able to say something. I actually did.
I'm aware. Okay, let's get into the regulatory milestones, okay? First of all, mine closure plan. Now, the respondent said in the counter memorial that we hadn't fulfilled that obligation. I think you've said in your report that we effectively did, and I noticed that you don't bring it up in your presentation. So can we just strike the mine closure plan off the list?
Podemos retirar.
We can remove the closure plan, but what I said is that there is no support that it was presented. That is to say that the guarantee supporting the closure plan was presented.
Understood. On the mine inspection, you accept at paragraph 120 of your report that on the 7th of September 2018, IMC communicated to the DGM that had completed development and preparation activities and had requested an inspection, correct?
Correct.
And you further accept at paragraph
Correct.
120 that it had requested the suspension of the inspection on the 17th of October 2018 owing to the blockade, correct?
Eso es lo que se...
That's what is stated in the communication, correct?
And then you accept at paragraph 122 that IMC provided the requested documents, because they had been requested some documents that they were requested a week earlier, and a week earlier, they had requested that the inspection take place, correct?
Correcto.
Correct.
And you even accept at 123 that the DGM actually planned to carry out the final inspection between the 23rd and 25th of January 2019, correct?
Correcto.
Correct.
But of course, we can agree that the blockade
I'm
was...
sorry, sir. Again, we're speaking too fast, and the problem is the audio is not catching your answer in Spanish, so we're not going to have an audio of it.
Actually, I think this is probably my fault this time. Excuse me, I'm going too fast. So, from the 23rd to 25th of January, there had been some arrangements made to do the inspection, correct?
Lo que...
A document was issued by the ministry to schedule the meeting in January. And as part of this scheduling, there was a request for documents that had to be available during the inspection. Yes, that is correct.
And we can agree that the blockade was in place during that entire period, correct?
De acuerdo.
Based on what I heard throughout these days, yes, in January, there was a blockade.
And therefore, no inspection could take place, and that's why IMC again requested a suspension on the 22nd of January 2019. Is that your understanding?
Sí, correcto.
Yes, correct.
But if the inspection had been able to take place at the time of the request, 7 September 2018, and even allowing for an additional week to supply the as-built drawings, the inspection and authorization process, and all the other documents, the inspection and authorization process would have been completed within 25 days on the legal basis, or using your deadlines, 64 calendar days from September, correct?
Would you please repeat the last portion of your question? I want to understand if the deadline you are mentioning is just to carry out the inspection, or is it to consider that the inspection has been complied with?
So what I've done, let's just take your real examples. I've taken your 24 calendar days to schedule, and I've added the 40 calendar days for authorization that you mentioned, coming out to a total of 64 calendar days from September 2018. Does that sound about right to you?
No, that is not correct. It wouldn't be as of September, because even there were some documents that had not been presented up to December, and there is an additional comment here. Those 40 days that you just mentioned to issue finally resolution had to be supported with the environmental certification for water treatment, and that was not available. So we could take those days, but the permit would not have been approved.
We're going to come to the water inspection. Everyone loves talking about that underground water. So we will come to that. But right now I'm just talking about the inspection, okay? And on the inspection, taking your 64-day time frame, it would run from September because the blockade was in place, correct? That's what delayed the process.
No.
No. it would have been impossible to do the inspection in September or October, November, or December up to the 21st, because it was only then when Invicta presented the documents requested by the ministry.
Ma'am, you're excluding the time period during which the Invicta had requested that the proceedings be suspended.
Claro.
Yes, but suspension doesn't imply that it can be carried out if if the documents are not ready. I don't think I'm following you. You can restate your question, but as of September, you could not have that deadline running.
Let's take it in stages. The request comes in September. Then the time frame's running. There's a mine invasion in October and a blockade set up. Now, I respect that you say the timeline has to run from December because that's when the request for clarification came. But that request for clarification came only when my client thought the blockade had been ended and it requested to unsuspend the proceedings.
Let me see. When one requests the second stage of this permit, one needs to produce certain documents. And those documents include the quality assurance certificate. So if the submission is not complete, the deadline does not run, the time frame does not run. The certificates requested by the ministry are not related to a field task. These are tasks that are done at the desk level, maybe in Lima. So it would be incorrect for the time frame to start running at that date.
And you've explained and accepted the fact that a week after they asked for in December that the proceedings be reinstated, they got this request for 3 additional documents, correct?
No, that is not exactly the case. In December, it was scheduled, but there was a longer list of documents that was attached to it.
And they provided them a week later, correct?
The only thing that they presented on December 21st were the quality assurance certificates. At that point in time, the ministry issued the scheduling for January, and they also attached a document requesting further information for the inspection. And the record does not show any support that Invicta had this information.
Ma'am, that's not what you say.
Excuse me. ¿Tiene usted la fecha?
Do you have the date of that quality assurance certificate? Yes, it was presented on December 21st, 2018. That is the submission date. Is that a document that already existed, or was it prepared at that point in time? I do not have that information because I apologize. The attachments are not there. So they only attach the letter whereby Invicta is sending the ministry the quality assurance certificates. These are quite voluminous documents, and I imagine that's the reason why they were not attached. But when the inspection was scheduled, so the inspection was requested with the submission of certain documents. The ministry verified the first preliminary stage and says, okay, fine, now I can schedule. Now they issue a document with additional requirements that need to be available for the inspection. Those documents are not part of the file because the inspection finally did not take place, and I think it is very important to highlight, to underscore, that the inspection, Mr. Garibaldi, that inspection verified the construction of the mine as approved. It is likely that in this inspection, the authority, that is the Ministry of Energy and Mines, saw a significant modification inside the mine, and that is the alternative system that was explained on the first day as quite a significant component. I didn't have that much information because I heard that there was a digging in the rocks with some ditches. So the tribunal is aware of all that. We shouldn't waste our time on that. Excellent. Please go ahead.
They suspended proceedings on the 14th of October. The request for that, I'm reading from your paragraph 120 and 121. The request was answered on the 23rd of October, and in the report, the DGM said, you still have to submit 3 things. Quality assurance, as well as a final work report and as-built maps. You don't say they only provided one of the 3. You said that they, December 21st, attached the requirements demanded by the DGM. But I think it's relevant to that exercise to include the fact that just the week before, my client had actually asked to reinstate the proceedings. So my point to you is, why would they have sent all that stuff in if they didn't think the inspection could take place? Because the blockade was in place.
I understand the confusion now between us when we're looking at this. These 3 requirements that you mentioned indeed were presented. Those 3 documents are only to schedule the inspection. To be able to carry out the inspection, you need a broader listing, a wider listing of documents, and the file does not reflect compliance with that list. That's what I'm saying.
Inspection, correct?
Because to schedule the inspection, you need those 3 documents requested, yes.
And they were provided and they scheduled the inspection.
Correct.
But in the intervening 2 months between the point at which they had originally asked for the inspection and then they supplied the documents, there was a blockade prohibiting anyone from going up to inspect the mine, correct?
Correct.
And you don't take account of those 2 months when you say that the inspection and the timeframes that relate to it, including the water license and the water inspection, could only run from December 21, 2018, correct?
No, acá de nuevo hay una confusión.
Once again, we have a confusion with the permits. What I am saying here is that in the inspection for the mining permit could only take place in December because it was only then when the documents would have been available to schedule the mine inspection.
I still don't understand that.
Mhm.
If they ask me, if I have to fight for some administrative proceeding, and one of the requirements is that I present my birth certificate, and that proceeding is suspended for whatever reason, and then I present my birth certificate 3 months later, it doesn't mean that I didn't have my birth certificate at the original time. So I have a conceptual problem with this, that the tribunal has to look at this as a but-for scenario. And you are, if I understand your report correctly, you are constraining the but-for scenario on the basis of the real world. I have conceptual problems with that. Can you comment?
Por supuesto, mil gracias.
Of course, and I deeply thank you for the question. I agree that presenting it in December does not imply that you didn't have them earlier, but that gives some doubt, gives room for some doubt. If they presented the request in September and they had the documents, why didn't they submit them? They knew it was a requirement. Why did they submit an incomplete file that will only have the times just take longer? So this is just a hypothetical situation. But what we saw here is, okay, December 14th, they presented their request, and not even then were the documents presented to support it. They were only presented a week after. So here, my recommendation would have been, if you would like for the time frame to be complied with, please do produce the full file because it is important. Sometimes permits do take time because the quality of the file is not good enough. And in this case, the history tells us that they presented 5 ITS. 3 of them were not approved due to technical deficiencies. So I do understand the difficulty to understand the actual time frames, etc., but sometimes that goes hand in hand with the quality of the technical material that is presented to the authorities. And as I just mentioned in this case, and this is my personal opinion, I would have presented, if I am short of time, I would have presented full information so as not to delay the inspection.
Let me interject here and just alert the parties that we are about 45 minutes out from our scheduled rising time, and I don't know how that fits with the expectations for the continuing cross-examination, any recross, but we do have a time bar racing up on us.
Sir, I will do my best to finish in the allotted time.
Will there be any time for recross should respondent desire it?
I'll do my best. I did take the break to try and cut down.
No, I appreciate that, but I'm just alerting you that time schedules around here are real.
I believe that. I will be judicious, sir. So let's talk about the ITS, everyone's favorite topic. We're agreed that in the 12th of November 2018, the DGM rejected the third ITS because it had constructed the component before the environmental assessment, correct?
Esa fue una de las observaciones.
That was one of the observations that was not cured, correct?
Okay. And you've set out in your 104 that the IMC had to dismantle the alternative water management system and then reapply for the permit and build it all again because I think you say that the use of an ITS was likely a gray area. Is that roughly your view?
Está mezclando dos temas.
You're mixing 2 topics here in your question. They are completely different.
Let's point. You don't cite any examples in your report of other instances in which a company had to take an entire facet of a mine down and then get the permit and then reapply, correct?
Correcto, pero en los propios documentos.
Correct, but in Invicta's own documents, if my memory serves me right, there was a request to dismantle a component that was built without a permit. But going back to your question, it is true, but at the same time, it could be, as we said it in the regulation, if it is built without approval, it won't be approved. Invicta needed to have approval to be able to have the authorization for exploitation.
Just again, in the interest of the time warning I just received, the question was, do you provide examples in your report? And I believe the answer was no. Do I have that correct?
Yes.
Okay. And clearly and presumably you were here and disagree with Mr. Bravo's statement that often you can tear something down and rebuild it, but you'll get a fine. But you do appreciate that Mr. Bravo works for mining companies, also has a legal background, and that's his experience. You accept that that is his experience, correct?
With due respect to Mr. Bravo, yes, indeed, I listened to him yesterday, but Mr. Bravo said several things that are not in accordance with the legal regulatory system in Peru. Based on the experience that he mentioned, indeed, he has worked with mining companies, and working with a mining company does not imply that one has the regulatory expertise. Even being attorney for a mining company does not imply having the mining regulatory. In most of the companies that I work with, the regulatory area is very well defined and separated, for example, from the legal manager who sees more of procedural labor issues. The regulatory sector is quite specialized, and with due respect, I consider that he did not have complete information on the permits.
Okay. Now, I appreciate that sometimes legal deadlines are real and sometimes they're legal, but you'd also understand that sometimes regulations, companies will ask for forgiveness rather than permission. And that's his experience. Do you accept that that ever happens in Peru?
Estoy de acuerdo que pasa.
I agree that it happens, but in this case, the issue was not for them to be fined. The issue was that Invicta needed to certify the system. And if they had the component built, the authority could not certify it. So this is not accepting a fine or not. This has to do with the fact that as long as the component was there, it was impossible to certify it. If it couldn't be certified, it was impossible to have authorization for exploitation, and if they exploited, it would have been illegal miner.
So let's talk about the MTD and the PAD. You noted earlier that the MTD, which is sort of embodies this idea of forgiveness rather than permission, was created in 2014, correct?
Correcto.
Correct.
Limited period of time.
Correcto.
Correct.
And then the PAD procedure was created in May of 2019, correct?
Correcto.
Correct.
And you discard the PAD procedure on that basis because it was not available as of October 2018, correct?
No, no es correcto.
No, that's not correct.
Lo descarto por
I discarded because of 3 reasons. First, because indeed in 2014 it was not available, so it couldn't really apply in this case. Let us move ahead in time, May 2019. In May 2019, May 2019 comes and the company wants to apply this. The most evident point, in my opinion, that makes this inapplicable is that in the case file, nothing is said about the application. And then in May 2019, I understand that the discussion roundtables were there and they were in a position to present it. What's happened, I think, is what Mr. Bravo said yesterday. He said that he was focused on lifting the blockade and that he was not focused on permits. Yes, this existed, the PAD existed, but Invicta did not apply it. Let's go one step further. Let's imagine that Invicta had applied the PAD. I'm sure that you were going to ask me that next. If it had applied, what would have happened in that case is that perhaps it could have operated, but the environmental certification, which is what the MEM requires for providing the exploitation authorization, that would have come only with the approval of the PAD, and that approval would have been obtained by them, as I said in my presentation, by mid-2020 at least. Taking into account those 3 points, I think that it is not applicable in this case. My opinion is not the most evident thing. The most evident thing is that it was not applied, although it could have applied.
I'm going to, again, ask you to perhaps keep the answers limited to the questions.
I answered your question.
And then some.
It was all the answer to the question.
Okay. I didn't ask you about what would have happened if they applied, did I?
But I thought it was important.
I gathered that.
Well, Council, now we're going on to a detour.
Yeah.
That's what she said.
Let's move on.
Yeah, so let me just get the timeline straight. The MTD is available in 2014, and it lapses. But then, in December 2017, there's issued a draft regulation announcing that they're going to make available the PAD. Do you recall that?
No.
Okay, let's pull it up on the screen. It's Exhibit C494, and it's at tab 10 of your bundle. This is a resolution dated 21 December authorizing the publication of the draft Supreme Decree creating the PAD procedure. Have you seen this document before, ma'am?
No recuerdo haberlo.
I do not recall having seen it in detail.
Okay. And then the second document I want to show is tab 11, which is C494. And if we can go to page 10 of this document, 495, excuse me.
Disculpe, ¿cuál?
Which document did you say?
495, which is on the screen in front of you, on the right-hand side. Now, my understanding is that this document is the actual Supreme Decree draft, and it's of the same date, 21 December 2017. If you look, it has a provision on the 10th page discussing the creation of the PAD. So my question is, you're aware that it was public knowledge at the time that my client had its ITS rejected that this PAD mechanism was going to be available imminently.
A ver, ahí no es.
I do not agree with you 100% because in my experience, many draft regulations were published that were not passed. Perhaps in the future that could have been approved. We are talking about a year and a half difference, taking into account the dates you told me. But my doubt is, if they were so sure that the PAD was going to come out, why did they apply an ITS trying to include a document that was not prepared when the meeting was had? And the most important point is, if they were so interested in applying the PAD, why didn't they apply for the PAD? So to apply for the PAD, well, the information that you have to submit is cabinet-related information, cabinet-level information. So this is not an issue of suspicions, it's an issue of facts. The company did not apply for the PAD.
We're agreed they didn't apply for the PAD, but there were some intervening events. And what I'm asking you is not why didn't they apply for a PAD? They couldn't have in 2018. But at the time their ITS was rejected, the draft bill had been out for nearly a year. So wouldn't a rational company said, well, we got the ITS rejected, why don't we just wait to see if we can get a PAD? That's what a rational company would do, right, Ms. Dufour?
No, una empresa diligente jamás.
No, a diligent company would have never planned its action on the basis of draft regulations. If the question is that, it is not diligent to rely on a draft piece of regulation.
Ma'am, that's not what I asked you. I didn't ask you if they were planning to do a PAD. I said that when they got the rejection in November, mind you, that rejection came, and you also have the intervening event of the blockade. But in that time, why don't they could have just said, well, we'll wait for a PAD instead of applying again for the ITS. That was an option that they could have considered. Whether you think they were diligent or not, I'm not asking that. Do you think that that was an option that they could have considered?
No hubiese sido una opción que yo.
It wouldn't have been an option that I would have recommended to them.
Okay. Let's move to social license. Now, looking at your CV, I can't see any coursework that you've undertaken on social license issues in the CV, correct?
A ver,
To answer your question, I think I was clear when I made my presentation that the social license is not a legal concept. I've also was clear that this is a goal that you have to obtain via the use of tools. For example, the compliance with commitments, also citizen participation.
mi currículum sí he puesto
In my curriculum,
I have an objection. Let's hear what Mr. Foden's objection is.
I have very limited time. The question was just about her CV.
That's-
And I'd really be appreciative if perhaps we could have an admonishment from the tribunal to simply limit the answers to the questions I've asked 3 times now.
I'm not really in the business of admonishing people. I prefer to encourage and persuade, but it is true that some of these answers are getting a little long. The question was, have you had academic training that would qualify you to I understand that was the question, was of that order, and the answer to that I guess is either yes or no.
académica, no.
not academic in nature, but yes, in the practical side of things. I have worked in many citizen participation processes, and that are part of the tool used to get social licensing. And also, I have been involved in many social commitment or social compliance audits. So I consider that I am qualified.
Okay. We had a statement from the witness of what she regards as her qualifications. Why don't we move on?
Did you conduct a site visit to Peron or interview any Peron members when you put together your report on social license?
No.
No.
And in your report, you cite to 6 academic articles on social license and the definition thereof. Did you author any of them?
Did you? Sorry, I didn't understand.
Author. Did you write any of them?
No.
No.
And I don't see on your CV that you've ever written any articles on social license.
Correcto.
Okay.
Correct.
And at paragraph 350 of your report, there's a suggestion that the Peron community's initial concerns about the environmental impact of the project could somehow legitimate Peron's grievances with IMC. Do you agree with that interpretation of the paragraph?
Un segundo.
Just one moment. I'm going to read it.
Ok, lo que digo en
What I'm saying in this paragraph, the first portion of it, is a fact that indicates that OEFA has imposed sanctions on Invicta because of non-compliance with environmental and social regulations. What I said is that those social and environmental breaches may have an impact on the trust that the communities have in connection with the company. And then what I say is that the Peron community, on the basis of the documents that I have reviewed, had concerned in connection with boundaries, land boundaries, environmental matters, social matters, and that could have created an impact on the relationships that the company had with the community.
Now, after Peron complained to the local water authority, the ALA, on the 10th of April 2018 about the alleged presence of white water, and then the ALA conducted an inspection that did identify some cloudy water, are you aware that IMC sent laboratory tests to AFA showing that the mine influence complied with the MPLs?
Está mezclando dos autoridades. Primero me habla una inspección de la Autoridad Nacional del Agua.
You're talking about 2 different things. One is the ALL, and then you have talked about results sent to OEFA. What inspection are you making reference to? These are 2 different authorities that oversee different matters. Could you please explain that, please?
I don't need to explain the 2 different entities. You're aware of them. I'm asking you if you're aware that IMC sent lab results to AFA showing that the mine effluents complied with the MPLs. Are you aware of that?
No estamos hablando entonces.
We're not talking about the ANA inspection that you indicated first. Excuse me, you posed me a question, but your question was kind of mixing up things. So I need to make sure what you're asking to be able to. First, you talk about the ANA inspection.
IMC sent lab results to UEFA showing that the mine effluents complied with the MPLs. We can look at the document if you need to.
Excuse me, Mr. For operational reasons, we may need to take a brief pause here. So let's.
No, sir, what I meant is that I know we're pressed for time, but we're really losing a lot of the audio in Spanish, so you really need to pause before you answer.
De acuerdo.
Beware of
Agreed.
saying take a pause.
No, I don't have any. No. Can I answer?
Slowly, please.
I promise. I think I had too much coffee today, so.
Yes, I am aware of the fact that Invicta sent some monitoring tests saying that they had complied with the regulations, but they sent them as a defense in connection with the sanction imposing procedure that UEFA initiated against it because it went over the MPLs. And UEFA looked at the information and they said, okay, when Invicta took these samples, they complied with the regulations. But when UEFA went there, they did not comply with the regulations. I think they went over the MPLs by quite a lot. We've seen this in the past few days. So a sanction was imposed on Invicta. Not only was a sanction imposed, but also UEFA considered that there was a risk of environmental image. It imposed a corrective measure in order for the company to implement an alternative system.
With respect, that's just not correct. If we look at paragraph 42, and again, I don't speak Spanish, unfortunately, on page 16.
Of what, please?
Sorry, of the exhibit I called earlier, which is R74, which can be found at tab 19 of the bundle. Page 16, as I understand it, determines that as of that date, which is the 27th of September 2018, right before the blockade, the MPLs were within the MPLs. Do you see that?
Sí lo veo.
Yes, I see that. But again, this is the sampling that Invicta sent at one point in time. But if we scroll down in this resolution, we're going to see that Invicta was sanctioned because it went over the MPLs.
Tab 20 at page 10 of the English. This is exhibit C408. And then a different agency, the ALA, conducted an inspection of the Invicta mine, and it reached the conclusion at paragraph 6.3, and this document is dated the 13th of July, so it predates the exoneration by UEFA, and it says that no direct impact on the water resources of the Peron community in the surrounding areas. Do you see that language, ma'am?
But sorry, you have said, disculpe.
You have said, and I need to clarify this, that UEFA exonerated Invicta from the penalty. But in the other document you showed me, well, it clearly states that a sanction was imposed. Not only was a sanction imposed, but a corrective measure was imposed as well. I wanted to say that in this resolution, no exoneration exists. going back to the ANA document, yes, a control was conducted in July, and this inspection ended with a sanction imposing proceeding, not because of an environmental matter, but because of the fact that water was used without any authorization in the Huecocha stream. Just for you to know, OEFA looks at the MPLs, which is the quality of the effluents, and the ANA looks at the body of water.
I perhaps shouldn't have used the word exonerated. I can admit that. But all I asked you was whether you saw that paragraph. Okay. At paragraph 265 of your report, you say a social license is based on mutual trust, correct? If a trust, you would agree with me that there has to be some reciprocity between the two counterparties in terms of actions that create credibility and that mutual trust, correct?
Correcto.
Okay.
Yes, correct.
Now, I understand your report to say that you would agree with me that securing surface rights agreements is an important step, not the only step, but an important step in moving up the levels of social license that you identify. Are we agreed?
No.
No.
Okay, at paragraph 399, you say that surface land agreements, the latter, definitely support social license.
Correcto.
That is correct. They support them, but as I said in my presentation, one thing is the access to the surface rights, and a different thing is the social license with the corresponding tools. Yes, and that is correct.
And yeah, that's what I said. I said not the whole thing, but it's an important step. And you're aware that my client concluded surface agreements with both Laxanga and Santo Domingo, aren't you?
Correcto.
Correct.
Now, you're aware that you say at paragraph 397 that IMC was required to cover several items under its EIA, such as training activities, education, health support activities within the three communities, correct?
Correcto.
Yes, correct.
In the interest of time, I have a number of documents. I can read them out for the record, but you're aware that IMC carried out a series of trainings in agricultural techniques, community management, community relations, and health campaigns in all three of the relevant communities, correct?
Correcto. Pero también hay documentos.
Yes, correct. But there are also documents in which the community relations company says that they only conducted activities in two of the three communities, and it excludes PERAN from all of this.
I'm afraid I need to interject. I've now gotten a very emphatic note beginning, really underscored large print. We need her to pause because there's no audio in the Spanish. So we really need you to count to 3, because otherwise we at this stage we don't have a complete Spanish requirement. So really we need you to...
I'm very sorry.
Sorry has nothing to do with it, but please pause.
Okay.
Mr. President, can I just ask Mr. Granet a question about timings, if you don't mind? At this,
Be happy to ask him,
Okay.
Mr. Grenay. What do you envision in the way of redirect?
As of now, nothing. No redirect.
All right, can we take that to the bank as of now?
As of now, yes.
All right, thank you. Does that address your
it
question,
expedites things. It does,
Thank you.
indeed.
I ask your target time to finish.
I believe that our deadline today is 5:40. It's bang on. Okay. So let's look at one of the documents that establishes what I was just talking about. Just look at one. Tab 25, which is Exhibit 438. So this is a training plan for agricultural techniques. And you see that the place date and the communities refers to all three. Do you see that?
Sí, correcto.
Okay.
Yes, correct.
Now, this is one of several documents that explains these plans. They're Exhibit C 440, for the record, 441 and 442. You don't cite to any of those documents in your report, do you?
I would have to look, but possibly no. I haven't cited all of the documents that were issued by Community Relations.
Did Peru's council provide you with those exhibits when you were assembling your report?
Me dio el acceso.
It gave me access to all of the information in connection with Community Relations. Yes, correct.
And you didn't comment on them, you didn't feel necessary to comment on the community relations, I'll get there, community relations training documents that were put on the record.
I have made reference to a number of documents from the CR team, but not that one, indeed. But we could ask about many others. I have not made reference to a number of documents. That's correct.
Now, as an expert, I'm allowed to ask you hypothetical questions, all right? So I want you to accept for the moment that my client's position, that it didn't need a social license with Peron because its mine infrastructure wasn't located on Peron. Just accept that position for purposes of our discussion. In that event, you haven't actually opined on whether my client obtained a social license with Santo Domingo or Laxanga, correct?
The fact that there are no components, that does not mean that the company shouldn't have the social license. The EIA and the ITS is clearly established.
The question to you was whether there, in your opinion, a social license had been established as to these other two communities. Do you have a view as to that?
Yes. De acuerdo a la
Yes, according to the literature that you have had access to, the social license cannot be looked at individually or independently. It has to be looked at on the basis of the project. In this case, the three communities, assuming that there is no component in Peron, the three communities are included in the area of direct social influence on the basis of the EIA, or rather the environmental management document. So in order to assess the social license, I have to look at everything together. I cannot exclude Peron.
Perdone, pero eso significa
Excuse me, but that means that if a community in the area of influence denies a social license, that's enough. Then there is no social license at all. Is that what you're saying? In that case, I consider that what the company should do is to invest more time in a dialogue to obtain the social license. In my experience, I have had a number of clients that have taken years to get a social license, and they're able then to start or operate a project. If we're talking about a community that is located in the direct influence area, both from the social and the environmental viewpoint, there has to be a good relationship with the community. This is a risk that is known by the mining companies, and all of the mining companies that conduct studies in this regard identify this as one of the main risks, because the ore cannot be moved. The ore is in one location. Next question. What happens if a community in bad faith, for reasons unrelated with mining operation, decides not to grant this social license that you're making reference to? What is the obligation that the company has in that case? In my opinion, and what I've seen in practice in the communities, oftentimes what the companies do is wait some time. For example, they wait until there is a new governing committee, and then they can go deeper into the dialogue to obtain the license. If there is no coexistence between the two parties, the process is not going to be fruitful because they're going to find constant opposition. What has happened in many cases, if the company has had the bad luck to be faced with opposition, I have seen examples where when the project has not moved forward, and that has happened in Peru in some cases.
Is there any limit to the time and resources that a company has to put into such an effort?
It's not that it has to put it into it if it considers that it doesn't have the time or resources. It can also decide to not go forward with the project. It's a risk that is identified not only in Peru, but in many other countries as well, and not only in mining, but also in many of the extractive industries.
So I want to see if I can understand that point. You're saying it's binary in that you either choose to wait it out or you don't. Is that correct?
Well, if you put the question in those terms, it would be wait and do nothing, wait, doing something, engaging in dialogue, or if it is verified at the end of the day you're not going to get a positive result, then you also have the option, for example, to sell the project or to withdraw. Yes.
Okay, that's fair. But it doesn't answer my question of, is there a limit on, what if the company is publicly listed and it's committed to that project? It's told all of its investors in Canada that it's going to drive forward with that project. Is there a limit to the amount of time that you, in your expert opinion, they would have to spend before they just basically disregard that one community and say, do business with the other two? Or do they have to wait ad infinitum?
Let's see. What I'm saying is there's not any regulated limit. There are companies. Well, I have a client who waited 10 years to engage in relations up until the point the community accepted it. And I have clients who, at the end of the day, after 2 months, reach the conclusion that it's not worthwhile. But it's the same risk that a mining, social license is one risk, but also the risk of finding ore. It's a high risk, but it is a risk that all of the mining companies are familiar with, not only in Peru, as I say. This is a risk of the top 5 established in all risk assessments that there are in mining. And it's a high risk, but it is the risk that exists. I think it's not correct. You're an expert. As an expert, you have to respond to hypothetical questions or questions posing hypotheticals. Very well, then. If, in effect, there's been violence, weapons, crimes, bad conduct that is outside of the legal framework, then yes, I would consider that that's not the correct attitude. I would think that in that case, the community is not acting correctly. But I would repeat, in this case, those facts are under discussion or under debate, and therefore my answer doesn't apply to the case.
I finished early, Mr. President. I'll leave 7 minutes there for somebody. Thank you, Ms. Dufour.
Thank you.
All right, well, we have got, that's very admirable. Thank you. We have finished the direct examination. Do we have no recross? Do we have any questions from the tribunal?
Let me try to establish a couple of things about social license. As I understand it, let's put us. Let me start again. let's put aside all of these specific obligations imposed by the law in connection with the environmental impact statement. I'm not saying that they are not important. I'm saying that let's put them aside for purpose of this discussion. We have testimony here to the effect that the social license goes beyond those obligations. Okay, do you agree with that?
I agree with that.
Okay. We also have testimony or statements to the effect that obtaining and maintaining the social license is an obligation of the company. Do you agree with that?
It's a goal of the company. Yes, I agree
It's a
with
goal.
that. Yes.
But not an obligation.
It's really, if you want to say it's an obligation, not a legal obligation, but yet it's a goal, because if there is no social license, it will be very difficult to execute the project.
Okay. So you anticipated the next question. It's not a legal obligation.
Correct.
Now, it is an obligation of the company, which doesn't have a reciprocal obligation on the part of the community. The community is not obligated to provide that license, right?
That is correct, but the community needs to have also a mutual respect with the company.
Needs to have, doesn't have to have, as I understand it.
Social license? No. The social license is one way. The social license,
is one way. It's
Yes.
unilateral.
yes.
And it is permanent. So in other words, that it can be revoked at any time. It's something that the company has to maintain by doing whatever it needs to do to obtain it.
Yes, because they need to have a good relationship with the communities, and that's how they can maintain the social license. Yes.
All right. So the way I understand it, let's conceive of this as an obligation, although not a legal obligation. But if it is an obligation of the company, it is an obligation of result, right?
There I need to precise. It's an obligation of result, but you said that I need to leave aside.
Yeah, leave aside all of those things.
But
all of
there are the means.
That's right.
So
I know, those
it's
are the
results and
fine.
means.
But the excess, that extra that the company is obligated to obtain and maintain, that's a result, isn't it?
It's the goal, yes, to get the social license.
Right. Okay. I think that's it for my purpose. Thank you.
Thank you for the question.
Well, I make the observation that I always found your suggestion that social license is a metaphor is a useful way to think about it. And with that gratuitous observation, I wonder, do we have any further business to transact this evening?
Not on the part of the claimant.
Anything further on the respondent? Okay, so we will, I see we have some of our evaluation experts. We will turn to hearing from these gentlemen or ladies and gentlemen, whatever we've got on Monday. I thank everyone for their cooperation. It's been a busy day, and the witness is now excused. We thank you for your testimony, ma'am, and I wish you all a good weekend. Those who are going to be here, safe travels for those who are going to be traveling. We'll see you on Monday, usual time.
Thank you very much.